All right, fantastic. Then without further ado, this is the first annual Vincent LaGuardia Gambini University of Houston Law Center Intrateam Mock Trial Tournament. So we have Team Ridiculous Suit on the plaintiff side and the defense team of the 2007 Britney Spears. The Honorable Judge Alex Boylhart presiding. Judge Boylhart, take it away.
Sure. Can we just start just real quick with introductions? Plaintiff counsel, please just tell me your name.
Yes, Your Honor. My name is Youssef Abdelhafiz, and alongside my co-counsel, Billie Parker, we represent the plaintiff in today's case.
Hello, Your Honor. My name is Alejandra Rodriguez. This is my co-counsel, Mycal Dede, representing the defendant, Officer Sandy Riker.
Plaintiff, any motions in limine or housekeeping matters?
No motion in limine, Your Honor, but a few housekeeping matters. Before we proceed, we'd like to invoke Rule 615, the constructive sequestration of all witnesses, barring party representatives. The plaintiff in today's case, the party representative, will be Ms. Corey Jacobs.
Granted. Anything else?
Yes, Your Honor. May we assume that all screen sharing takes place outside of the presence of the jury until exhibits are admitted into evidence?
You may.
Thank you. With that, the plaintiff is ready to proceed to opening statements.
Defense counsel, any other housekeeping matters?
Yes, Your Honor. May we assume all witnesses have been pre-sworn?
Yes.
May we assume all evidence has been pre-marked?
Yes.
Your Honor, as you know, pursuant to Federal Rules of Civil Procedure 51, the jury charge may be read prior to or after closing arguments. For purposes of this trial, we ask that the jury charge be constructively read prior to closing arguments.
It's granted.
That concludes our housekeeping matters.
Okay. All right, opening statement. Plaintiff's counsel.
May I proceed?
You may.
Your Honor, opposing counsel, ladies and gentlemen of the jury, I bet you wish you had kept your mouth shut yesterday. That's not something you typically hear from an officer making an arrest. But on October 26, 2019, the defendant, Officer Sandy Riker, said these words to Mr. Corey Jacobs when she decided to retaliate against Mr. Jacobs for expressing his First Amendment rights. Today's case is about an arrest and the events that led up to that arrest. You see, Mr. Jacobs was a law student at the University of Columbia who was living there with 3 other roommates near campus. On Friday, October 25th, the day before Mr. Jacobs' arrest, he had come home to a large party thrown by his roommate, Tate Duncan. Eventually, Mr. Jacobs noticed 2 officers standing in the open doorway, one of which was the defendant. Mr. Jacobs approached the officers, expecting a noise complaint, but the defendant pushed past Mr. Jacobs without saying a word and went after Mr. Duncan. Right after Mr. Duncan got away, the defendant turned her attention towards Jerry Hoffman, another one of Mr. Jacobs' roommates, and demanded Ms. Hoffman turn over her phone. This is when Mr. Jacobs decided enough was enough and informed Ms. Hoffman that that if the defendant did not have a warrant, she did not have to turn over her phone. This led the defendant to confront Mr. Jacobs and let him know that he should shut his damn mouth. Soon, Ms. Hoffman chose not to turn her phone over and the defendant left the party. But that wasn't going to be the last time Mr. Jacobs saw the defendant. You see, the next day, the defendant had spotted Mr. Jacobs at a rally and spotted an opportunity. The defendant arrested Mr. Jacobs and let him know exactly why he was being arrested. I bet you wish you had kept your mouth shut yesterday. This is why we're bringing a suit against the defendant for violating the First Amendment rights of Mr. Jacobs. To prove our case, we must show that 1, the defendant acted under the color of the law, and 2, that the acts of the defendant deprive the plaintiff of his particular rights under the Constitution. This second element can be proven by showing 3 additional elements. That 1, the plaintiff engaged in speech or expression protected under the First Amendment. 2, the defendant took action against the plaintiff. And 3, chilling the plaintiff's protected speech was a substantial or motivating factor for the defendant's actions. Now, we must prove each of these elements by a preponderance of the evidence, that it's more likely than not. Think of today's trial as a set of scales. with each piece of evidence as weights. And when you place the plaintiff's and the defense's evidence on this scale, if by the end of your trial, your scale is tipping ever so slightly towards the plaintiff, then you must find for the plaintiff. So in order to provide you with evidence to place on your scales, we will be calling two witnesses. First, we will be calling Mr. Corey Jacobs. Mr. Jacobs will tell you about how he met the defendant when she came to his apartment. He will tell you about how the defendant shoved past him in the apartment and told his roommate, Ms. Hoffman, to turn over her phone. He will tell you about how he told his roommate she didn't have to turn over her phone if the defendant didn't have a warrant. You will hear how the defendant told Mr. Jacobs that he should shut his mouth. You will hear that when Ms. Hoffman refused to turn the phone over, the defendant left the apartment, but it wasn't the last time Mr. Jacobs would see the defendant. Mr. Jacobs will tell you about how the next day at a rally, he saw that someone had started a fire in the parking lot. He will tell you about how it was collapsing, so he tried to throw the trash and debris into the fire away from cars and other people's paths. But when he threw a can into the fire, he was immediately being handcuffed despite never drinking anything. You will hear that it was the defendant handcuffing Mr. Jacobs and the defendant who told Mr. Jacobs, "I bet you wish you had shut up while I was talking to your friend yesterday." Then we will call Miss Phillip Norwood, a classmate and a friend of Mr. Jacobs, and one of the witnesses to Mr. Jacobs' arrest. Miss Norwood will corroborate Mr. Jacobs' testimony by reiterating how Mr. Jacob never drank any alcohol that day. She will tell you about how when she saw Mr. Jacobs trying to put out the fire when the defendant grabbed Mr. Jacobs and arrested him. She will tell you about how the defendant only arrested Mr. Jacobs despite there being 20 other individuals with beers in hand. And she will tell you about how she heard the defendant say, "I bet you wish you would have kept your mouth shut yesterday." At the end of today's trial, my co-counsel, Ms. Parker, will come before you and remind you of the evidence and testimony that we will present before you. And we'll ask you to place the evidence on your scale. She will remind you about how the defendant chose to retaliate when she arrested Mr. Jacobs and how the reason for the arrest was because Mr. Jacobs didn't keep his mouth shut. She will ask you to find the defendant liable for violating Mr. Jacobs' First Amendment rights. Thank you.
Defense counsel.
May it please the court, counsel, ladies and gentlemen of the jury. This is a case about an officer doing her job. Nothing more. The plaintiff wants you to believe there's some vendetta going on, but quite frankly, it's simple. Officer Riker saw a crime being committed, and she made an arrest. She was just doing her job. My name is Alejandra Rodriguez, and along with my co-counsel, Mycal Dede, we represent the defendant, Officer Sandy Riker. Today, you're going to get to know Officer Riker. What you're going to learn is that she is a dedicated public servant who finds joy in her commitment to protect and serve the citizens of Overton. And she sits here, away from the community she works tirelessly to protect, wrongly accused of an offense she did not commit. The plaintiff is going to get up here today and try to spin you a story of revenge and retaliation. They want you to believe our client acted outside the boundaries of her work, but in reality, they are presenting nothing more than the typical actions of any officer looking to uphold the safety of their community. The evidence will show that in all her years of service, there is no question that Officer Riker knows Overton, knows its laws, and knows probable cause. The facts of this case are straightforward. Contrary to what the plaintiff will tell you, split into two very separate events. On October 25th, 2019, Officer Riker and her partner arrived at a home looking to arrest Tate Duncan, a known meth dealer who the police had been investigating for months. They entered into the home in search of the suspect, but were instead confronted by the plaintiff, Corey Jacobs. The evidence will show that Mr. Jacobs, your typical teen at a loud house party, did not respond too positively to two officers showing up at his door. As Mr. Jacobs held up the officers, the suspect, Tate Duncan, was able to escape. But in the moments right before Duncan exited the home, he had a phone he handed over to Jerry Hoffman. Now, Officer Riker knew that in order to successfully arrest this dealer, to take him off the streets of Overton, The information on that phone could be helpful to their investigation. The evidence will show Officer Riker approached Jerry Hoffman and attempted to inform her of how that phone could help their case. But before Ms. Hoffman even had a chance to respond or to form her own decision on whether to help our client, Mr. Jacobs approached and decided to involve himself in the investigation. What you'll learn today is that Mr. Jacobs decided to play attorney for Ms. Hoffman, insisting that she refused to aid Officer Riker in catching Tate Duncan. Corey Jacobs took this opportunity to show off what he learned during his first year of law school. He didn't think about Officer Riker's investigation. He didn't think about the safety of the community. He only thought about himself. But thankfully, despite Mr. Jacobs' decision to interfere with Officer Riker's investigation, Tate Duncan was still arrested that night and taken off the streets. The following day, October 26th, Officer Riker was called in to respond to an unauthorized fire during a protest at an Overton beach. She arrived to find a large crowd of people drinking beer around a dangerously large fire burning in an access parking lot. The fire raged, fueled by empty beer cartons, cans, and even fuel accelerant. And in that crowd of drunk protesters was the plaintiff, Corey Jacobs. The evidence will show that 19-year-old Mr. Jacobs had a can of beer in his hand, and he decided to throw that beer into the fire, all in front of our client. Witnessing a violation of Overton Municipal Code, our client knew she had to do her job and respond to the crime she had witnessed. What you're going to learn today is that the plaintiff's actions gave our client, Officer Riker, enough cause to arrest Corey Jacobs that night. There was no retaliation involved, like the plaintiff would like you to believe, whether it was Jacobs or any other individual that night. Our client was doing nothing more than following the standard procedures of her job, arresting an individual who committed a crime. We are going to bring two witnesses today, Officer Sandy Riker and Dr. Aaron Bradshaw, to tell you about what happened the night of Corey Jacobs' arrest. Officer Riker is going to tell you what she saw that night at the protest and how her observations led her to make the decisions that she did. Dr. Bradshaw, an expert in police practices, is going to take an objective look at what Officer Riker did that night at the protest and tell you that there was probable cause to arrest Corey Jacobs. What you're going to learn is the importance of probable cause in Officer Riker's line of work, including in her arrest of Jacobs that night. In short, ladies and gentlemen, we expect all the evidence presented to you today to show Officer Riker had probable cause to arrest Corey Jacobs for violation of Overton's open container law, and for that reason alone. No petty squabble, no retaliation, no revenge, just a clear, run-of-the-mill violation of the law. It's simple. But if it's so simple, why are we here? Because the plaintiff filed a complaint. And for his claim to prevail, the plaintiff must prove that 1, Officer Riker acted under the color of the law, and 2, that he was deprived of his right to free speech through retaliatory arrest without probable cause. As you've heard from my opposing counsel, they're also going to call witnesses, and I want you to listen to what those witnesses are going to tell you. One is the plaintiff himself, and the other is his good friend. Such a good friend that Jacobs arranged legal representation for his deposition. Members of the jury, I remind you that this is a civil case, and Plaintiff Corey Jacobs must prove his case by preponderance of the evidence. It is up to you to decide what version of the events were more likely than not to have occurred. Is it more likely that there was some sort of grudge involved, or was Officer Riker just doing her job, responding the way any reasonable officer would? At the end of this trial, the plaintiff will ask you to find our client liable for retaliatory arrest. But based on the evidence you will hear, you will find that Officer Riker was doing nothing more than the standard duties of her job. I am confident at the conclusion of this trial, you will find our client not liable. Thank you.
Plaintiff's counsel, call your first witness.
Yes, Your Honor. Plaintiff calls Corey Jacobs. May I proceed?
You may.
Mr. Jacobs, please introduce yourself to the jury.
Hi, my name is Corey Jacobs.
How old are you, Mr. Jacobs?
I'm 20 years old.
Where do you live?
I live in Overton, Columbia.
And is Overton where the events giving rise to this lawsuit occurred?
Yes, Yes, ma'am. At the times, that's where I was living in an apartment with 3 other roommates near Columbia Law.
Mr. Jacobs, are you still a student?
No, I graduated and now I'm currently studying for the bar.
Why are you here today?
Because last October, my First Amendment rights were violated.
Which rights are you referring to?
My right to speech and expression.
And who violated those rights?
The defendant, Officer Sandy Riker of the Overton PD.
Do you see the defendant in the virtual courtroom today?
I'm not sure. I see her box. Yes, I see the defendant.
And can you identify the defendant by an article of clothing or a distinct characteristic?
Yes, ma'am. She has blonde hair and a black jacket.
Please let the record reflect that the defendant has been identified. Mr. Jacobs, when did you first meet the defendant?
It was on October 25th, 2019, at my old apartment at Oak Court.
You mentioned this apartment earlier, so I'd like to ask you a few questions about it, if that's okay.
That's okay, ma'am.
How long did you live there?
Less than a year. I moved at the start of 2019, the school year, so I would say probably August.
What made you choose that apartment?
I saw it in the student housing ad, and it was being subleased, so I thought it was cheap and it was close to the law school.
To clarify for the jury, what do you mean when you say sublease?
I mean, it's one person's name on the actual apartment lease, and then they rent out the rest of the rooms to other people, so it helps share the cost.
Who was this person who was renting the entire apartment?
Objection, Your Honor. Relevance?
Response.
Your Honor, we're merely introducing the plaintiff at this point and setting the stage for his interaction with the defendant.
Okay, overruled.
And who was the person who was renting this entire apartment?
That was Mr. Tate Duncan.
And did you know Mr. Duncan before renting a room in his apartment?
No, I just thought he was another university student that was taking the semester off. The rest of my roommates were undergrads at Columbia.
Who were those other roommates?
That was Miss Jerry Hoffman and Stephanie Simon. And like Tate, I'd never met them before moving in.
Let's talk about the night of October 25th when you first met the defendant. Who all was at your apartment that night?
There's a lot of people. One of my roommates ended up deciding to throw a party. So myself, all my other roommates, and about 40 other people.
Which of your roommates decided to throw this party?
Tate. It was Tate Duncan's party.
And when did the defendant show up at your apartment?
I don't remember the exact time. I remember looking over to the front door, and then I saw 2 police officers standing there, the defendant and her partner, and then they were pounding their fists on the door.
Were you surprised to see that the police were at your apartment?
No, honestly, the music was playing pretty loud and it was crowded, and I assumed somebody had made a noise complaint. I went over to the police and told them we would turn the music down at curfew.
Why approach the police officers?
Honestly, like I said, the music was really loud. I couldn't think of anything else that the cops were there to do, so I thought if I turned the music down, it would help solve the situation.
Now, at this point, did you have any idea that Tate Duncan was suspected of selling drugs?
No way. I wouldn't go to the party. I wouldn't even have lived there had I known anything like that about Tate.
You went to speak with the officers. How did that go?
It didn't. I went to speak to them about lowering the volume, and then the defendant immediately just shoved me past and then went to Tate's room.
Did she or her partner say why they were there?
No, I had no idea what was going on.
Did the defendant say that she had an arrest warrant for Tate Duncan?
No, she didn't.
So what happened after she shoved her way into your apartment?
Like I said, it looked like she was going to Tate's room, but suddenly Tate ran out a sliding back door, and then she followed that way. Then when Tate ran off, she came back to our apartment.
What happened after the defendant re-entered the apartment?
She went up to my roommate, Jerry, and began to hassle her about her phone.
What do you mean by hassle?
She was asking Jerry all these questions, and apparently Tate had used it at one point. Jerry told the defendant that Tate had used it to order pizza, but then the defendant, Officer Riker, kept demanding Jerry open the phone and prove to her by showing some recent calls.
How did you get involved in this conversation about Ms. Hoffman's phone?
I didn't like seeing her get bullied by anyone, and that's what the defendant was doing. She was being a bully, and the whole thing just seemed wrong.
So what did you say?
Objection, hearsay.
I told.
Response.
Your Honor, this is going into the conduct that night, so this is going to be effect on the listener of the defendant in response and to her interaction with the plaintiff.
You asked Mr. Jacobs what he said?
Yes.
Okay, overruled.
Mr. Jacobs, what did you say?
I told Jerry that if they didn't have a warrant for her phone, then she was protected by the Constitution from being forced to open it if she didn't want to.
Do you prevent Ms. Hoffman from opening the phone at all?
No. All I did was tell her what I learned in constitutional law.
And what is that?
That everyone has a Fourth Amendment right to be free of warrantless searches and seizures. Like Jerry was an undergrad, and other people like her just don't know that they have that right.
Who made the decision to not turn over the cell phone?
It was Jerry. Jerry did it all. It was her phone, and all I did was just tell her about her rights.
How did the defendant react to your involvement?
Bad. She made a point that I wasn't a lawyer and that it was in Jerry's best interest to cooperate. And then she looked at me and said, if I were you, I'd shut my damn mouth and stop interfering in the situation.
How did you respond to that?
Objection, hearsay.
Response.
Your Honor, I would say, again, this goes to the effect on the listener, to the defendant, informing her actions with the plaintiff.
Overruled.
How did you respond to her telling you to shut your damn mouth?
I told her that I had a First Amendment right to express my opinion, and if she didn't have a warrant for the apartment, then she needed to leave.
What happened after you said that?
She and her partner left, and the party was over after that. Then later we found out that Tate got arrested in a park near the edge of campus. So clearly they were able to find Tate without the cell phone.
When did you next see the defendant?
It was the next day. I was attending the rally at Overton Shores Beach, and that's where she decided to arrest me, and only me, for allegedly violating some alcohol ordinance.
Okay, we'll get back to that. I wanted to ask you, what was this rally about that you were attending?
It was about a protest against offshore drilling by Overton Oil.
And what were you doing at this rally?
I mostly just stood around and listened to the speakers. There was a stage on the beach and a bonfire nearby, and there's then speakers talking through a megaphone.
How long were you out on the beach listening to people speak?
I don't remember exactly, but I left sometime after the sun started to go down.
Where did you go after you left the beach?
I walked back to the parking lot where I saw some people from school just acting stupid.
What do you mean by stupid?
They were building an oil derrick out of empty beer cans, and someone lit it on fire in the parking lot.
Just to clarify for the jury, what is an oil derrick?
It's kind of this tall looking kind of tower. They use it to, when you drill wells, it lowers the pipe and stuff in there. something like that. And someone else also wrote Overton oil sucks on the oil derrick.
So who started this fire that you saw in the parking lot?
I have no idea, but people were throwing their trash into the fire and trying to use their beer to put it out.
Was that working?
Honestly, it looked like it was getting bigger. With cans of fuel fusion, I'm not surprised.
What is fuel fusion?
It is a lighter fluid from Overton oil. I saw some of the cans mixed with a bunch of beer in the parking lot. They look pretty similar. Apparently, one of the rally organizers had used it to start the beach bonfire.
Your Honor, this time I'd like to direct the witness and opposing counsel to open their case files to page 59, what has been pre-marked as Plaintiff's Exhibit 1.
Okay, granted.
Now, Mr. Jacobs, do you recognize Plaintiff Exhibit 1?
Yes, ma'am.
Without describing Plaintiff's Exhibit 1, what is it?
It's a photo of a can of fuel fusion.
And is this photo a fair and accurate depiction of the cans of fuel fusion you saw that night?
Yes, ma'am.
Your Honor, at this time, I move to admit Plaintiff's Exhibit 1 into evidence, tender to opposing counsel, and publish to the jury.
Any objection?
No, Your Honor.
It's admitted.
Now, Mr. Jacobs, are you able to see my screen?
Yes, ma'am.
And is this a fair depiction of the cans of fuel fusion you saw in the parking lot that night?
That's correct.
Now, you also said that you saw some beer cans. What did these cans of beer look like?
They look like your basic Coors Light can, silver, aluminum.
If you were to see a photo of these cans, would you recognize them?
Yes, ma'am.
Your Honor, at this time, I'd like to direct witness and opposing counsel to page 58 of their case files, which has been pre-marked as Plaintiff's Exhibit 2.
Okay.
Mr. Jacobs, please let me know when you have Plaintiff's Exhibit 2 in front of you.
I'm there.
Do you recognize Plaintiff's Exhibit 2?
Yes, ma'am.
And without describing Plaintiff's Exhibit 2, what is it?
It's a photo of a Coors Light can.
And is this photo a fair and accurate depiction of the cans of beer you saw in the parking lot that night?
Yes, ma'am.
Your Honor, at this time, I move to admit Plaintiff's Exhibit 2 into evidence, tender to opposing counsel, and publish to the jury.
Any objection?
No, Your Honor.
Okay, it's admitted.
Now, Mr. Jacobs, is this a picture of the can, one of the cans of beer you saw at the beach?
Yes, ma'am.
And just to clarify, this is one of the other cans that you saw at the beach, correct?
The ones that I could see, yes.
Now, what other types of cans did you see in the parking lot that night?
Like I said, I couldn't really remember. Those are the only two that I could actually see. There's so many cans. There's like 500 people drinking at the rally, and I would guess like half of them were drinking beer. So the whole parking lot was filled with a bunch of beer cans.
And did you see any other types of cans mixed in?
I didn't see, but yeah, there easily could have been other beer cans there.
Now, is it legal to be drinking beer on the beach?
No, and that's why it was kind of stupid for them to do so.
And what did you do when you saw this fire in the parking lot?
I tried to get around it to my car, but the fire just kept getting in my way.
What do you mean by it was getting in your way?
There was a pile of cans that the fire knocked over, and it got near me. And I saw a can or something near me, and I picked it up and tossed it into the fire and away from me.
Why add to this fire?
Honestly, all I was thinking about was the trash. I figured it was better to get it out of people's way and into the fire. And when I grabbed the can of liquid, I said, shoot, maybe it might help take the fire out.
What did you think the liquid was?
Honestly, I didn't look or think about it. I just wanted it out of my way.
What happened after you tossed the can into the fire?
I don't know what happened after the fire. When the can left my hand, my arm got jerked back, and then the cuffs were slapped on me by Officer Riker.
Did you realize that the police had arrived?
No, I was pretty distracted by the fire.
And what, if anything, did the defendant say to you?
I just remember the defendant telling me, I'll bet you wish you had shut up while I was talking to your friend yesterday. And that's when I knew.
When you knew what?
But the only reason I had the handcuffs on me was because I talked back to Officer Riker the night before.
Objection,
I wasn't-
speculation, Your Honor.
Response.
Your Honor, this isn't speculation about why he was being arrested. This is speculation about how he felt at that moment. He's not
May I
speaking
respond,
for
Your
Officer
Honor?
Riker.
Yes.
No, this is a clear example of him saying why he believes he was arrested, Your Honor. This isn't his impression of what happened at the time. This is what him saying why he believes he was, Your Honor, and he's improperly framing things.
I'm going to sustain the objection.
Now, how did you feel about the arrest that took place?
It
Objection,
made me
relevance, Your
afraid.
Honor.
Response.
Your Honor, his emotional state at the time is incredibly relevant to proving damages and liability.
May I respond, Your Honor?
You may.
This trial is bifurcated. We're not assessing damages. We're only doing liability right now.
Your Honor, I would argue that this still would be necessary information to establish liability in this case.
Overruled.
How did this arrest make you feel?
It made me afraid. It made me angry. The defendant used her power to try to ruin my life, and just because I exercised my First Amendment right to speech.
Thank you, Mr. Jacobs. Pass the witness.
Cross.
Yes. May I proceed, Your Honor?
You may.
How's it going today, Corey?
Sorry. It's going good.
Good. Would you like me to call you Corey or Mr. Jacobs?
Either one's fine.
Alrighty. I just want to ask you a couple more questions. But just to confirm, you do admit that you picked up the beer can, correct?
That's correct.
Okay. And the night Officer Riker arrested you, you weren't arrested. I'm sorry, the night you were arrested by Officer Riker, that wasn't the first time you two had met, correct?
That's correct.
And you had met at the house party the day before, correct?
Can you repeat the question?
I'm sorry, I may be cutting in and out. You met Officer Riker at your house party the day before, correct?
That's correct.
Now, when Officer Riker came into your apartment, she didn't approach you, did she?
Well, she shoved right past me.
But she didn't come at you, did she? You approached her, didn't you?
Initially, she just ran into the apartment.
Mm-hmm. And you testified that you made your way you were on your way to tell her that you would turn the music down at a later time when you saw her come into your house. Is that correct?
That's correct.
And then, as a matter of fact, you approached her a second time when you interjected yourself into the investigation. Is that correct?
I was just letting my roommate know her rights.
You testified that you weren't sure why the officers were at your apartment, but you later found out they were there for drugs, correct?
No, I thought they were there initially for the volume and the party.
But later you did find out they were there for drugs, methamphetamines?
Later, yes.
How long did you live with Tate Duncan before the night of that party?
Before the night of that party?
Mm-hmm.
I'd probably say maybe 2 months.
And you had no idea he was selling drugs?
No, like I said, I would never have gone into the apartment or signed a lease.
You never noticed strange people coming by, lots of money, different smells, nothing tipped you off?
Objection or relevance, Your Honor?
Response.
Your Honor, we believe they opened this the door to this line of questioning when they denied that he had any knowledge of him selling drugs, and I think it goes to speak to the witness's credibility and involvement in the operation.
What's the relevance to the issues in this case?
This case is about this witness's credibility and retelling the story that happened. I think if he can't be honest about this thing, then he might not be honest about another thing.
Your Honor, may I respond?
Yes.
This line of questioning does not produce any information that makes any fact in this case more or less likely. Therefore, it is not relevant to the facts of this case.
I'm going to sustain the objection.
Your Honor, may we have any response? I don't believe he actually made a response.
We'll move forward. Would you agree that drug dealing is a serious offense?
Absolutely.
So it wouldn't surprise you that the police officers were taking this seriously, would it?
I'm sorry, taking what seriously?
The investigation, trying to get the phone, being in your apartment.
Like I said, I initially thought they were there for the volume, so I didn't really know what was
Well,
going
that's
on.
not what I'm asking. What I am asking is that it wouldn't surprise you that they were taking this investigation seriously, would it?
A drug investigation is a serious thing.
And you still chose to get involved in that, even though you believed it's serious.
Objection, Your Honor. This mischaracterizes my client's prior testimony. He's already
Response.
admitted that he had no idea what was going on at the time.
Response.
I'll concede, Your Honor. I'm just clear. Okay. Let's talk about the night of the arrest. At the protest, were people drinking?
Yes.
And is drinking on the beach at Overton, is that an arrestable offense?
I believe so.
And you know, as a law student, you have to abide by all of the laws, correct?
Just like everybody else, yeah.
Not just the laws that you like, but all of them, correct?
That's
Objection,
correct.
ask and answer.
Sustained.
When you testified that you picked up a can and you wanted to, you thought that the can might put the fire out, correct?
That's correct.
And you also testified when you picked up the can and tossed it into the fire, you alleged that you had no idea what was inside the can. Is that correct?
Other than some liquid.
And you did just testify that there were two types of cans on the beach. Is that right?
That I can see, yes.
Yes. And you knew one of the cans, you're not maybe sure what a can of Coors Light. Is that what we testified to or agreed to, Coors Light? You don't really know what would happen if you threw that in the fire, would you?
No.
But we do know what happens if you threw a can of Overton oil into the fire, correct?
Yeah.
That's a fire accelerant, isn't it?
Yes, sir.
So your testimony here today is that you were very concerned about the size of the fire, but you may have been throwing a can of oil into the fire?
Like I said, it was trash and I didn't really get a great look at it.
No further questions, Your Honor.
Redirect.
Briefly, Your Honor. Mr. Jacobs, how many types of cans did you see in the parking lot that night, for certain?
There's hundreds. Like I said, there's like 500 people there. Half of them were drinking. I don't know if they were just drinking Coors Light, and I doubt they were drinking only accelerant.
No further questions. May this witness step down?
You may. Plaintiff's counsel, call your next witness.
Yes, Your Honor. At this time, plaintiff calls Ms. Phillip Norwood to the stand. May I proceed?
You may.
Can you please introduce yourself to the members of the jury?
Sure. Hi, my name is Phillip Norwood.
What do you do for a living, Ms. Norwood?
I'm a law student at the University of Columbia.
How has law school been for you?
Man, It's tough, but I enjoy it. I'm pretty involved with a couple of organizations, and I'm actually on the moot court team currently.
So how did you meet Mr. Jacobs?
We met in law school. We had some classes together. We were in a study group, and we even attended some rallies together. We actually both volunteered to organize a rally in Central Park that was put on by the LGBT Society.
Are you friends with Mr. Jacobs then?
Yes, we're friends. We got to know each other through school and realized we have some of the same interests and support similar causes.
So is that why you got involved in this case?
No, I was actually subpoenaed by the defendant in this case.
Well, even if the defendant subpoenaed you, how do we know that you wouldn't lie for your friend?
I'm under oath. If I lied, I could face huge repercussions that would affect my career. Corey and I are friends, but I would not throw away my entire future to lie for him.
So how are you involved in today's case?
Well, I was at the protest rally with Corey the day he got arrested on October 26th. I saw him during the rally, and I actually also saw him when he got arrested.
Who was in charge of this rally?
I was one of the organizers. It was a rally that we were hosting against the offshore drilling at Overton Shores.
Was Mr. Jacobs one of the organizers?
No, he was not. I actually invited him to the rally.
What happened at the rally?
Well, we had a bonfire set up at the beach, and then we also had a stage at the beach. And then some of the community members, including myself, were going to take turns giving speeches.
Was there any alcohol at this event?
Yes, most people were drinking beer.
Did you see if Mr. Jacobs was drinking beer?
I could see him when I was on stage, and he was not drinking.
What about when you weren't on stage?
No, I lost him in the crowd right before I got off stage.
Did you see Mr. Jacobs again at the rally?
Yes, I was going back to my car in the parking lot to pick up some flyers, and I saw Corey in a crowd.
What was going on in this parking lot?
Well, someone had started a fire in the parking lot, and people were burning empty cases of beer. There was some beer cans stacked up, and people were trying to put the fire out.
Was Mr. Jacobs drinking at any point when you saw him?
No, he was not.
And so what was Mr. Jacobs doing?
He was trying to put out the fire until
Your Honor,
some burning boxes.
speculation.
What was the objection?
Speculation.
Response?
Yes, Your Honor. I asked the witness what she saw Mr. Jacobs doing. This witness is simply going based off of her rationally based perceptions, what she observed Mr. Jacobs doing.
May I respond, Your Honor?
You may.
She can testify to his direct physical actions, not to his mindset in undergoing those actions.
Yeah, overruled.
Ms. Norwood, so what was Mr. Jacobs doing?
He was trying to put out the fire until some burning boxes had collapsed and kind of started to spill towards the van. Corey then started kicking the beer cans and burning material back into the fire and away from the cars.
What did you do when you saw this?
Well, I started to walk up to Corey, but then a cop grabbed Corey and told him he was under arrest for violating the open container law. I later learned the cop was Officer Riker.
How far away were you from them when this happened?
They were less than 2 feet away from me.
Who else was around?
There were about 20 people in the parking lot with beers in their hands.
Did the defendant arrest anyone else that day?
No, just Corey.
Did the defendant say anything else to Mr. Jacobs?
Yes. He said, "I bet you wish you would have kept your mouth shut yesterday."
Thank you. No further questions. I pass the witness, Your Honor.
Cross?
Ms. Norwood, you're an activist, aren't you?
I guess so, yes.
You've been involved in several protests, correct?
Yes.
And you're passionate about the issues that you advocate for, right?
Objection, Your Honor, to
I am,
relevance.
yes.
Response?
Trying to establish the plaintiff's motives for being there and any potential biases that she may have in favor of the plaintiff.
Overruled.
Yes, Your Honor.
Go ahead, counsel.
Let me ask one more time. You're passionate about advocating for these issues, right?
Yeah.
Would you consider yourself vocal in wanting to support these causes?
Did you say vocal? I'm sorry.
Yes, sorry. Would you consider yourself vocal in wanting to support these causes?
I don't know. I mean, law school is my full-time job, so I do this on the side. So I don't know how vocal I am about it.
Of course. Well, I'm sure you appreciate the importance of getting people, riled up to support these causes and continue their mission, right?
Yeah, I like to see people passionate about the causes, sure.
Now, Mr. Jacobs believes a lot of that stuff too, doesn't he?
I think
Your
that we
Honor,
have
to
some
speculation.
Well, what's the objection?
To speculation, Your Honor. Opposing counsel asked Mr. Jacobs believes a lot of these same passions as well.
Response?
I can move on, Your Honor.
Okay.
I mean, you've stated in prior depositions that you and Mr. Jacobs support similar causes, right?
Yes, we do.
You also stated in those depositions that Mr. Jacobs loves to fight for a good cause.
Yes.
In fact, it wasn't the first time you met Mr. Jacobs outside of school at a protest.
No, it was not.
Would it surprise you to see in your deposition that you stated that the first time you hung out with Mr. Jacobs outside of school was at a protest?
No, it would. I'm sorry. When I said no, it was not, I meant it was not the first time that we had hung out at a rally together.
No, Ms. Norwood, I'd like to talk to you about the evenings of an offshore drilling rally.
Okay.
You were an organizer for that protest, correct?
That's correct.
And you were tasked with speaking to the crowd from the stage on the beach?
Yes, I gave a speech.
Did you see Mr. Jacobs that evening?
I did, yes.
But you weren't attending the rally with Mr. Jacobs, right?
No, I was an organizer, as you said.
In fact, you didn't speak to Mr. Jacobs at all that evening, did you?
No, I tried to, but by the time I got to him, he had been arrested.
And you want this court to believe that Mr. Jacobs wasn't drinking at all that night, right?
Not that I saw, no.
But you didn't see Mr. Jacobs for most of that night, correct?
I don't know about most. I mean, I saw him when I was on stage, and then I saw him again in the parking lot. But yes, there were times I didn't see him.
There were large periods of time in which you didn't see Mr. Jacobs at all, correct?
I guess it depends on what you think large is, but there was definitely time periods where I didn't see him.
Now, you saw Mr. Jacobs at the parking lot connecting to the beach, right?
Yes, that's right.
You were there to collect flyers from your car?
That's right.
You weren't there to see Mr. Jacobs?
No.
And immediately after grabbing your flyers, you returned to the rally, correct?
Yes.
Ms. Norwood, as a law student, I'm sure you know that a person can decide which laws they want to follow, right?
Yes, I do know that.
You know there's an ordinance in Overton that says you can't have an open container on the beach, correct?
Yes, I do know that.
And you know it's an arrestable offense.
I believe so. I don't know the ordinance by heart, but yes, I believe so.
Ms. Norwood, you've known Mr. Jacobs the entire time you've been in law school, is that right?
That is correct.
You're good friends with Mr. Jacobs?
We're friends, yes.
In fact, you're such good friends that Mr. Jacobs arranged for you to have counsel during your deposition, right?
That's correct.
He set it up so you wouldn't have to go out and worry about finding an attorney of your own, correct?
Yeah, I thought it was kind of her. Yeah.
And now you're here to testify for Mr. Jacobs, correct?
I am, yes, but I was subpoenaed by the defendant.
That'll be all, Your Honor.
Redirect?
No redirect, Your Honor. I simply ask that this witness be allowed to step down.
She may.
And with that,
go ahead.
I apologize, Your Honor. With that, the plaintiff rests its case in chief and requests a brief 5-minute recess.
Yes. That's granted. Why don't we return at 6:52? Let's return at 7
Your
on the
Honor,
dot.
prior to the recess, we would like to see if we can make a motion constructively outside the presence of the jury.
Sure, absolutely. Go ahead.
So we move for a motion for judgment as a matter of law. We believe the plaintiff has failed to provide sufficient evidence to establish and support its cause that the chilling of the plaintiff's First Amendment right was a motivating factor for the arrest on October 26th.
Response?
Yes, Your Honor. We believe that we've provided more than a scintilla of evidence that would lead a reasonable jury to believe that the killing of Mr. Jacobs' rights was a motivating factor behind this arrest. Specifically, the eliciting of the testimony that the defendant told Mr. Jacobs while he was being arrested that I bet you wish you would shut your mouth the very night before.
Okay. Motion's denied. Let's take a recess until 7 if there are no other motions. All right. Thank you.
Before we proceed, Your Honor, I'm not sure if all the judges are back, but may we request a time check just to see how much time we have left?
Yeah, I don't know. Is anybody else keeping track of that? I know obviously we started at 6, it's 7 now.
I kind of am. Everybody seems to be fine on time.
Yeah.
I wouldn't worry about it.
Thank you.
Okay, we have everybody? Yeah, we have
I'm
everybody.
present.
Okay. All right. Anything before we begin? Everybody ready? Ready? All right. All right, defense, call your first witness.
Of course. We'd like to call Officer Sandy Riker to the stand, please.
Okay. You may
May we
proceed.
proceed? Thank
Yes.
you. Can you introduce yourself for us today?
Sure, my name is Sandy Riker.
And how long have you been a police officer?
About 3.5 years now.
Do you like your job?
I love my job.
What are some of your favorite aspects of your job?
Probably just getting to interact with the community every day. I mean, I'm always meeting new people, and there's not a lot of jobs where you can do that.
That's great. You arrested Corey Jacobs because you believed you had probable cause to arrest him. Is that correct?
Objection, leading.
Response.
I'm just laying the foundation for why she arrested Corey Jacobs.
Sustained.
Essentially. Okay. Why did you arrest? What led you to believe you had? Why did you arrest Corey Jacobs, Officer Reichert?
Well, I watched him pick up an open container of beer and toss it into a fire, and there's a prohibition against having an open container on the beach in Overton, and I saw it with my own eyes. He committed a crime right in front of me, so I arrested him.
And you believe you had probable cause to arrest him?
Yes, he committed the crime right in front of me, so that satisfied kind of the bare minimum probable cause.
And can you tell us what exactly is probable cause?
Sure. So probable cause is basically, given all the circumstances known to the officer at a time, would a reasonable police officer come to the conclusion that there is a fair probability that a person either had committed or was committing a crime.
Okay. And you were in the courtroom when Corey Jacobs testified. Is that correct?
Objection, leading.
Response.
This is a fact-based question. She was in the room or she wasn't in the room. This isn't leading.
Just rephrase your question. I'll sustain the objection.
Were you here in the courtroom today? Officer Reichert. Hello?
I'm so sorry. Yes, I was in the
okay.
courtroom here today.
Yes. Did you hear Corey Jacobs testify?
I did.
Now, Corey Jacobs seems to think that you held some sort of grudge against him. How would you respond to these allegations?
Objection, sidebar.
Response.
I'm not sure what she's objecting.
Your Honor, counsel's testifying.
I'm going to overrule the objection. Go ahead, counsel.
How would you respond to the allegations Corey Jacobs made against you?
I'm really sorry that that is how Corey Jacobs took the situation, but I in no way retaliated against him. I was only in his apartment trying to look for Tate Duncan. I was solely focused on trying to apprehend Tate Duncan. It really just had nothing to do with Mr. Jacobs.
But the night you met Corey Jacobs, that wasn't the first, the night you arrested Corey Jacobs, that wasn't the first time you two had met.
Objection, leading.
Response.
Again, this is a fact-based question. I'm not understanding how this is leading.
Sustained. Rephrase, please.
When was the first time you met Corey Jacobs?
In person, I had met him for the first time the night before October 25th, 2019, I believe.
And how did you guys meet?
Well, I arrived at his apartment to execute an arrest warrant against his roommate, Tate Duncan.
And who exactly is Tate Duncan?
I'm sorry, could you repeat the question?
Who is Tate Duncan?
Oh, Tate Duncan was the subject of a very big narcotics investigation. We had compiled a lot of evidence showing that Tate Duncan had been dealing methamphetamine from his apartment.
How long did you all work on that investigation?
See, we executed the warrant at the end of October and had been working on it since before August, so several months. This was a big case in the making.
Now, when you arrived to the apartment, did you go and approach Corey Jacobs?
No, Corey Jacobs had first approached me, but I was trying to walk over to Mr. Duncan.
So tell me what you did when you got into the house.
Sure. So after we entered, I saw Tate Duncan sitting in the kitchen. And as he saw me, he handed a cell phone to Jerry Hoffman and then proceeded to make his way through the bedroom and outside the back patio door.
Okay, so how did you and the plaintiff even begin to interact?
Well, I tried to chase after Mr. Duncan, and he'd clearly gotten out much faster than I could get to him. So because I saw him hand that cell phone to Ms. Hoffman, I had asked Ms. Hoffman if I could see the phone in hopes that it would maybe lead me to—
Object to the narrative, Your Honor.
Response.
The witness is answering a question that I specifically asked. I wanted to know how did they interact? I can break the question apart if she'd like.
Please do.
Okay. So I think when we left off, you said you saw Tate Duncan hand the phone to someone. Is that correct?
Yes.
Did you know who this person was?
Yes, he handed it to his roommate, Jerry Hoffman.
What did you do next?
Well, that's when I went and approached Ms. Hoffman, trying to see if she would unlock the phone so I could see who Mr. Duncan had just been communicating with, in hopes that we could help locate where he was.
And anyone try to stop you from getting her phone?
At that point, that is when Mr. Jacobs had interjected, but the conversation was really just between me and Ms. Hoffman.
So how did you respond to the plaintiff interfering? Sorry.
I just asked him to, please stay out of this, because I was really just focused with Ms. Hoffman, because we now had a known drug dealer who was on the loose and we weren't sure if we were going to be able to apprehend him. So I was just speaking with Ms. Hoffman.
Why did you all need the phone so badly?
Well, it's not that we needed it so badly, but in that moment, that was the last thing I saw Tate Duncan touch before he escaped. And that was my best chance to try to find out where he was headed.
After this exchange, you left the apartment, correct?
Objection leading.
Response.
I'll concede, Your Honor. Or I can rephrase that question, sorry. What did you do after this exchange?
Once it became clear that I wasn't going to get the phone at that point, we didn't want the situation to escalate any further, so we just left.
I want to talk a little bit about the night of the arrest. Why were you at that protest?
We had been called there because of reports of a large unpermitted fire in the parking lot that was getting out of hand.
And when you arrived, how many people were at this protest?
Well, I first got to the parking lot, so there's maybe about 80 people in the parking lot that I saw.
And were people drinking in the parking lot?
Yes.
Is drinking an arrestable offense at Overton Beach in the parking lot?
Yes, you're not allowed to have an open container of alcohol on the beach, and that is an arrestable offense.
So when you arrived, what was the first thing you saw?
Well, as I was approaching the fire, I saw Corey Jacobs pick up a beer can and toss it into the fire.
What did you do next?
I saw him commit a crime, so I proceeded to arrest him.
Now, out of all the people there, how is it that you saw Corey Jacobs first?
Well, like I said, I was approaching the fire and he was standing right next to the fire, tossing a can of beer into it. So, it's not like I tried to seek him out or anything. He was just the first person standing right there.
But cops have a lot of discretion. I mean, you didn't have to arrest Corey Jacobs, did you?
Objection leading.
Response?
I can rephrase that question.
Okay.
Did you have to arrest Corey Jacobs?
Well, no, but I saw someone commit a crime, and it's my job to, enforce the law.
Corey Jacobs believes the conversation you two had the night before the arrest was a really big deal to him.
Objection, Your Honor. Counsel's testifying.
Response?
I'm not testifying. I'm simply rephrasing what her witness stated. Witness stated he was angry. He said he felt embarrassed.
Your
He
Honor,
said
may
this
we
was a very
approach?
big deal to him.
Yeah, let's constructively approach.
Your Honor, this is not.
Go ahead.
Your Honor, counsel is saying he's not testifying, but he's also saying that he's repeating testimony and things that he heard. He's not asking a question. He's giving information to the witness.
What was your question, counselor?
Well, my question was this a big deal? Was the interaction the night that those two had the day before a big deal? And I believe that the opposing side opened the door to that line of questioning. I don't think it's a narrative at all.
Your Honor, I didn't hear a question in counsel's statement.
Yeah, as long as you phrase it like that, counselor, I'm fine with that.
Oh, sorry. Thank you, Your Honor. May I continue?
Yes.
So, Officer Riker, was the interaction you and Corey Jacobs had the night before, was that a big deal to you?
No, unfortunately, in my line of work, I'm pretty used to people getting angry with me and even getting up in my face. It's part of being a police officer. And, we're really trained not to take it personally. And like I said, I was very focused on just my conversation with Ms. Hoffman in hopes to try to apprehend Tate Duncan later on. That was my sole focus.
Thank you. I'd like to pass the witness, Your Honor.
Cross?
Yes, Your Honor. Now, I want to talk to you about the night of October 25th. That's all right, Officer Riker.
Absolutely.
You went to this apartment to arrest Tate Duncan, correct?
Yes.
But you didn't tell anyone why you were at the apartment.
The events happened pretty quickly. As soon as I got there, I had to start a pursuit against Tate Duncan. So no, I was not able to announce myself in that moment.
Okay, so just to clarify, you didn't tell anybody why you were at the apartment.
Not initially, no. I had to pursue Tate Duncan.
And you didn't tell anyone you had an arrest warrant for Tate Duncan.
I don't remember if I had said that or not. I may have.
And you wanted to look at Ms. Hoffman's phone.
Yes, I was hoping it would help us find Mr. Duncan.
And she didn't let you.
No, she did not.
And you didn't have a warrant for Jerry Hoffman's phone, did you?
No, we had a warrant just to arrest Tate Duncan.
And that's when Mr. Jacobs walked over.
Yes.
And he advised Ms. Hoffman of her Fourth Amendment rights.
Yes.
And that's when you told him to shut up.
I do not remember saying those words. I probably asked him to please be quiet and step aside.
But you definitely wanted him to stop speaking, correct?
No.
Objection, speculation.
Response.
I'm eliciting the actual response and the reason for why she wanted this person quiet. She's not speculating to events within her personal knowledge.
Overruled.
Officer Riker, you wanted him to stop speaking so that you could talk to Ms. Hoffman, right?
No, I was having a conversation. You can have conversations with multiple people talking.
So you were completely fine with him coming over there and speaking?
Like I said, I'm used to people getting in my face. I just kind of put blinders on and focus on my investigation.
And the night of the arrest, you were called to the beach, to the parking lot because of a fire, correct?
Yes.
And when you got to the site of the rally, you didn't make any arrests for arson, did you?
No, we did not know who had initially created the fire.
You didn't make any arrests for arson. You didn't make any arrests for disturbing the peace?
No, because we had seen the commission of more serious crimes happening.
And so you didn't make any arrests for disturbing the peace. You made one arrest, is that correct?
Yes.
You arrested Corey Jacobs
Yes,
for violating an open container law.
that's right.
And there were several people gathered at this rally, correct?
Yes.
And many of the people around you were drinking beer, correct?
Yes.
And the one that you arrested for open container law was Corey Jacobs.
Yes.
And you saw him pick up the can and throw it, correct?
Yes, establishing possession. Yep.
Now, that requires possession of an open container, correct?
Yes.
You're saying that from where you saw him throw that, you could see that the container was open.
I could see liquid pouring out of it. Yes. And I believe he testified to that earlier. Yes.
I appreciate that response, but I didn't ask what he testified to. The night of the fire, you say that you saw him pour an open container in there. You could tell that the can itself was open.
If I recall correctly, I think I could.
And I want to ask you a little bit. You said you've been doing this job for about 3.5 years. Is that right?
That's right.
And you consider yourself a good cop?
I'd like to think so.
You always follow the proper procedures?
I try my best.
Now, when you try your best, does that mean that sometimes you don't follow proper procedures?
I'm human.
Objection, relevance.
Your Honor, this is opened up on direct of this witness regarding her doing her job and basically being a good cop who likes to go out and do her job just to interact with people. I think this goes to her only to the extent of like her character as far as it was opened up on direct.
What specifically are you saying was the question or the answer that opened this up on direct?
That she stated that she was only doing her job.
Okay. Sustained.
Now, you did just say that you consider yourself a good cop, correct?
I like to think I am, yes.
And part of that is never violating your department standards, correct?
I'm not perfect, but I try my best to follow all the rules.
So would you say that you have never violated your department standards?
Objection, Your Honor, relevance.
Response.
Your Honor, this is a case about, this goes to the witness's credibility. She just stated that she always tries to follow proper procedures. If allowed to get into this questioning, I believe that we would establish whether or not that is a credible response.
Response.
Your Honor,
Mycal?
may we constructively approach, please?
Yeah, you may.
So, Your Honor, we believe that the plaintiffs are trying to introduce improper character evidence right now that is not relevant to the issues that we're trying to litigate today. We believe they're trying to bring in some of the incident that happened over 2 years ago that's trying to establish some sort of habit to say that because she did something one time here, she also did it the same time this way. We really don't think that's irrelevant. We think it's more prejudicial than probative, and we ask that you bar the type of evidence from getting in.
May I respond, Your Honor?
You may.
This is going into the intent of the officer. She had a reason to not react appropriately when she was spoken up to. We believe that getting into this past information would help to establish the intent of the officer, and for that purpose, character evidence of past wrongdoing would be allowed. Under 404.
I'm going to sustain the objection.
Now, I want to ask you one last question about the night of the fire. You weren't the only police officer there at the scene, correct?
No, I believe there was one other officer with me.
Now, at the scene or in general, are you saying that you were the only police officer to respond to this rally?
No, there was at least one other police officer with me.
Is it your testimony that there were no other police officers at the fire?
No, I just said there was at least one other there with me.
So then you're pretty sure there were other police officers around the fire?
Yes, at least one other.
Okay, so you don't know how many other police officers were there?
I remember coming with my partner, that was all.
And yet you're the only person who made an arrest for an open container violation, correct?
I only know about what I took care of that night because after I arrested Corey Jacobs, I went back to the police station. So you would have to check with the other officers.
That's correct. You went back to the police station. You didn't make any other arrest of the more than 20 individuals around you who were drinking beer, correct?
Objection, asked and answered, and relevance.
Response.
She hasn't answered this particular question, Your Honor.
Overruled.
Now, you said you went back to the station because you arrested Corey Jacobs. Corey Jacobs, you arrested no of the other 20 people who were there drinking in front of you. Is that correct?
Well, by the time I cuffed him, read him his rights, put him in my car, drove to the police station, booked him, and came back, most of the people had already scattered by then. So
that's right, because you chose to arrest the first person you saw who wasn't drinking from a can but throwing it into a fire.
Objection,
correct?
Your Honor. Opposing counsel is testifying right now.
That's the leading question.
Overruled.
No, that's correct. So by the time you were done, this was because you arrested the first person you saw throwing something into the fire, not one of the people who was actually drinking, correct?
The ordinance is not just whether you were drinking, it is mere possession alone established.
Officer Riker, I appreciate you reciting the ordinance to me, but just to ask my question, you arrested the person you saw throwing a can into the fire, not one of the 20 people that you saw drinking, correct?
I arrested the first person I saw violating that same ordinance. If
That person was not drinking beer at the time, correct?
Which is still a violation of the ordinance.
Okay. I'm just going to ask for a yes or no question. Yes or no, when you arrested Corey Jacobs, he was not drinking, correct?
I did not see him drinking, but he was possessing an open container of alcohol on the beach, which was a violation of the law.
I appreciate that. Officer Riker, if your opponent, if opposing counsel wants to get up and ask you more questions about that, you can give them that answer. And just to clarify, you did see other people who were drinking beer when you arrived at the beach, correct?
Yes, farther away from me.
And by coincidence, the person that you happened to arrest is the same man who spoke up to you the night before, correct?
Yeah. He was standing
no
closest
further
to the fire.
Thank you, Officer Riker. No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Officer Riker, does anything that the opposing counsel just asked you, does any of that change the fact that you had probable cause when you arrested Corey Jacobs?
No, I saw him pick up a can of beer, which was the clear violation of the Overton Code. He violated the law right in front of me, so I arrested him.
Okay. Thank you. No further questions, Your Honor.
Witness may step down. Defense counsel, please call your next witness.
Your Honor, the defense calls Dr. Aaron Bradshaw to the stand.
Okay,
May I proceed?
you may.
Can you introduce yourself to the court?
Hello, I'm Dr. Aaron Bradshaw.
Where do you work, Dr. Bradshaw?
I teach at the University of Columbia, but I also do some work as an expert witness on police practices. For that, I was teaching criminal justice for undergraduates at University of San Francisco.
How long have you been at your current job?
I began working at the University of Columbia in 2007, and I started consulting in 2010, and I started teaching in 2003.
And where did you attend school?
I received a bachelor's in criminal justice from UC San Diego in 2001. I then got my master's in criminal justice administration from the University of San Francisco in 2003.
Besides your education, do you have any other training in police practices?
Yeah, I went to the LAPD Police Academy in 91, and I was hired by LAPD in 92. Then I was promoted to captain in 97.
Why did you leave the police department?
I was shot during my last investigation, and I was medically retired.
Do you have any publications or research?
I do. I published a book titled Casual Analysis, The Determination of Probable Cause while I was teaching at USF.
In your 10 years working as a consultant, how many times have you testified as a police practices expert in court?
If we count this time, it'll be 27 times testifying.
As a consultant, you get paid to review the facts and render an opinion, correct?
Yes, I get paid. It's typical in this line of work.
You're committed to always rendering a truthful, accurate opinion, even if it might harm whoever hired you?
Of course, I'm a professional, and I always want to keep my work professional.
What's your involvement in today's case?
I was asked to review the police practices used during the arrest of Corey Jacobs.
What materials, if any, did you review?
I reviewed the statements from the parties and witnesses. I also interviewed the officers and reviewed their police reports. And I also relied on my own training and experience in criminal justice and probable cause.
Which officers did you speak to?
I spoke with Officer Riker and a partner, Officer Hollis.
Now, are these the kinds of things that an expert testifying in your expertise would rely on to come to an opinion?
Yes, these are the type of materials that experts typically rely on in my field, and I typically rely on them as well.
You don't have to personally witness the events to render an opinion?
No, if I review the documentation, I can constructively place myself in the situation and be able to assess it properly.
Did you form any opinions in this case?
Yes, I concluded that Officer Riker had probable cause to arrest Corey Jacobs.
Objection, Your Honor. Improper opinion under 702.
How so?
Your Honor, this witness has not been admitted as an expert in probable cause. He does not meet the 702 standards, specifically 702C and D. This witness doesn't have any reliable principles and methods that they used in coming to their conclusions, and they did not reliably apply these principles and methods to the facts of the case. If I'm allowed to voir dire the witness, I can bring this out in the voir dire.
Your Honor, may I respond?
Yes.
Initially, per local rules of this tournament, per local rules, there's no need to render a witness, an expert witness, as an expert in any particular field. Additionally, the testimony offered by the expert witness does satisfy the 4 necessary prongs of Rule 702. They have testified that the practices that they use are common. They've testified 27 times before with no issue using these very same practices that are industry standard. And I believe if there's any concerns that counsel has, they can go ahead and press them on cross, and anything that was priorly inadmissible can be issued in cross. And it should be up to the jury to decide whether they want to, the weight that they want to give to the expert's testimony.
Response, Your Honor.
I'll allow the voir dire on the witness constructively outside the presence of the jury. You may proceed.
Yes, Your Honor. Now, Mr. Bradshaw, I want to make something clear. You don't have a doctorate, correct?
No, I don't. I have a master's.
You don't have a PhD, correct?
No, I don't.
Now, Mr. Bradshaw, during your time on the police force, you didn't receive any specialized training in probable cause, correct?
I was a police officer.
You received the same training as the rest of the police force, correct?
Yes, and we received training on probable cause during the academy.
But you as an officer didn't receive any specialized training in probable cause, correct?
Well, I gained it through experience and then further during my studies.
You mentioned a book you wrote during direct examination. This book wasn't peer reviewed, was it?
I believe it was.
Is it your testimony today that your book was peer reviewed?
It may not have been.
Just a yes or no, Mr. Bradshaw. Was your book peer reviewed?
I don't remember.
You remember giving a deposition before trial, correct?
Yes, I do.
Would you be surprised if that deposition showed that your book was not peer reviewed?
If that's what the deposition says.
So that's a yes to my question. Your book wasn't peer reviewed.
I believe so.
This book's not even considered the gold standard in the field, is it?
I wouldn't know.
This book isn't widely accepted in the field?
It's my book. I'd like to believe that it's widely accepted and well received.
But you don't know if it's widely accepted, do you?
I wouldn't know what other people, personally think about my book.
You don't have any peer-reviewed articles about probable cause, do you?
I'm sure I've done some work while, teaching and studying.
Just a yes or no to my question. Do you have any peer-reviewed articles about probable cause?
Not off the top of my head. I don't.
You don't have any peer-reviewed articles regarding police practices in general, do you?
I don't know off the top of my head, counsel.
So that's a no to my question?
I don't know off the top of my head, counsel.
Would you like me to refresh your memory with your deposition?
If you could.
Yes. At this time, Your Honor, I'm directing opposing counsel and the witness in turn to open up what was previously marked as page 45 in their case packet.
Okay, proceed.
Mr. Bradshaw, do you have the deposition pulled up?
No, is there any way you can share it with me?
Yes, I can. Can you see that?
Yes, I can.
This is your deposition, correct?
Yes.
That's your name on the front?
Yes.
Everything you testified to in this deposition is accurate?
Correct.
And you included everything that was relevant, correct?
Correct.
You signed this deposition stating that everything was accurate, correct?
Correct.
Now, anywhere in this deposition, do you see where you mention having peer-reviewed articles regarding police practices?
I don't believe I mentioned that in my deposition.
So that was a no to my question then.
Well, just because it's not in my deposition doesn't necessarily mean that, counsel.
You included all relevant facts, didn't you?
Well, counsel, off the top of my head, I don't remember.
So is it your testimony today that you might have left out relevant facts in your deposition?
Counsel, the information I provided during my deposition and that I'm providing during testimony today is relevant.
So, Mr. Bradshaw, just a yes or no. Do you have any peer-reviewed articles regarding police practices?
Counsel, I believe so.
Despite that not being in your deposition?
I can't off the top of my head remember if there is or isn't.
Now, when analyzing the facts of today's case, you didn't apply any peer-reviewed studies, right?
No, I didn't.
You didn't apply any reliable tests to the facts?
I applied my specialized training and experience.
That's right. You just applied your personal opinion and personal experience.
That I gained from my studies as well as from my experience that is usually standard throughout the industry.
Thank you, Mr. Bradshaw. At this time, I re-raise my 702 argument, Your Honor, specifically 702C and D, that the testimony is a product of reliable principles and methods, and that the expert reliably applied these principles and methods to the facts of this case. As this witness stated, he applied his experience and knowledge, which suffices 702A, but 702C and D have still not been met, and this witness cannot be considered an expert in probable cause.
Response?
Your Honor, opposing counsel claims that the witness has been admitted a testimony that isn't the product of reliable principles and methods and has ineffectively relied on those principles and methods to come to the facts of this case. We argue otherwise. The witness has asserted that he has used these methods repeatedly, in fact, 27 times, even going forward to testify in front of Congress. Witness has asserted that these principles and methods are standard within his industry. The degree of education that the witness needs is in no place required to elevate up to a doctorate level. His time with a master's at undergraduate, his time in the academy, and his time teaching render more than enough experience to be able to feel comfortable in rendering an opinion on probable cause.
I'm going to overrule the objection to the testimony. Ms. Rodriguez, you may proceed with your direct.
Thank you, Your Honor. Let me ask my last question. Did you form any opinions in this case?
Yes. I concluded that Officer Riker had probable cause to arrest Corey Jacobs for violation of Overton's open container law.
Can you explain to the jury what probable cause is?
Of course. Probable cause exists when, under all the circumstances known to the officer at the time, an objectively reasonable police officer would conclude that there is a fair probability that the plaintiff had committed or was committing a crime. Probable cause can be met even though there was less than a 50% probability that a crime was being committed.
And using that definition, can you explain how Officer Riker had probable cause to arrest Corey Jacobs?
Under the circumstances, Officer Riker made the reasonable decision to arrest Corey Jacobs. She arrived to find a crowd of people drinking. She saw a large number of beer cans scattered around the unauthorized fire. She saw Jacobs reach down, grab a can, and throw it into the fire. These were all the facts known to Officer Riker at the time. I concluded that Corey Jacobs was likely to throw away a beer can into the fire. It was reasonable for Officer Riker to come to that conclusion as well.
Is it reasonable even if Officer Riker couldn't confirm that it was a beer?
I would say so. Her observation of the scene points to the probability that the can was a beer.
Dr. Bradshaw, why does it matter that there was probable cause?
Because it's my understanding that Corey Jacobs has alleged that there was no probable cause for his arrest. He's claiming there was another reason for his arrest, but I've concluded that the necessary probable cause was present and the arrest was justified.
What was the code Mr. Jacobs was found in violation of?
It was Overton Municipal Code Section 1433-1. It states that the use and possession of open alcoholic beverages.
Objection, Your Honor, to hearsay. Objection, Your Honor, to hearsay.
To your response?
The Overton Municipal Code is a public record. This is the law in question and a significant part of how the expert witness came to the conclusion.
Overruled.
Yes, Your Honor.
Let me ask one more time. What was the code Mr. Jacobs was found in violation of?
So that's Overton Municipal Code Section 1433-1. It states that use and possession of open alcoholic beverages is prohibited in areas such as the beach and adjoining access, like the one where Mr. Jacobs was arrested.
Does that mean that Mr. Jacobs had to be drinking to be found in violation of the code?
No, as long as he had an open container of beer, he was in violation of the statute.
Is violation of that statute an arrestable offense?
Yes, it's an arrestable offense.
In forming your opinion, did you account for whether anyone else was arrested for drinking that night?
No, I did not. It was not relevant in determining whether there was probable cause to arrest Corey Jacobs for an open container violation.
Did Officer Riker do anything wrong in arresting Corey Jacobs?
No, she was just doing her job.
No further questions. I pass the witness.
Counsel,
May I proceed?
you may.
Hello, Mr. Bradshaw. I'd like to ask you a couple quick questions. Now, before you retired, you conducted a no-knock search based off of probable cause, didn't you?
Objection, Your Honor.
What's your objection?
May we approach the bench?
Yes.
I anticipate counsel for the plaintiff is trying to get in information about a prior incident in Officer Bradshaw's policing career. I think it has nothing going on, nothing to do with this case. It has no bearing on his expertise and in fact can come in as improper character evidence.
May I respond on those grounds, Your Honor? Yes,
Yeah.
Your Honor. Now, opposing counsel entered this Mr. Bradshaw as an expert in probable cause based off of his experience. What I'm getting into is his experience with a specific case involving probable cause. This goes directly to the credibility of the witness if he's an expert based off of his experience. And this is additionally not character evidence as I'm not using it to show action in conformity therewith.
May I respond?
What happened in the incident? Someone let me know.
Yes, Your Honor. If I may proffer, a no-knock search was conducted. The wrong home, however, was raided, and an innocent person where there was no probable cause was killed as a result of this mistake. And this goes directly to the expert's credibility in regards of determining probable cause.
May I
So
respond?
they got the wrong house.
Yes, Your Honor. Yes, Your Honor.
How is that related to probable cause for that incident?
Yes, Your Honor. This search was conducted based off of probable cause. Now, if the expert had rated the wrong home based off of this probable cause, it would allow the jury to see whether or not this individual is truly an expert in probable cause if he made a mistake such as this that led to an innocent person dying.
Ms. Rodriguez, your response?
Thank you, Your Honor. I'd like to say that no, the probable cause in question was used to get a warrant to execute Dr. Aaron Bradshaw's last investigation. In executing that warrant, they entered the wrong house. This had no bearing on the probable cause, no influence on their perceptions of probable cause. Additionally, I believe opposing counsel is getting into this one case where there was a mistake while ignoring years of successful performance by Dr. Aaron Bradshaw, this single isolated incident, and he's trying to say that the expert was wrong so he must be wrong now and in every occasion following that event. I believe this.
I'm going to sustain the objection.
Yes, yes, Your Honor. Mr. Bradshaw, you reviewed the defendant's arrest report from the incident, correct?
Yes, I did.
And in the report, the defendant states that she witnessed several individuals spraying the fire.
Okay.
Do you have an
I apologize.
objection?
Yes, it's hearsay, Your Honor.
Response, Your Honor. Under 801 D2, this is a party opponent statement and therefore is admissible testimony in today's trial.
May I respond?
Yes.
The contents of the document are not admissions by a party opponent. They're a record kept by somebody else. There's no way to authenticate it and prove that there are accurate statements, that they were accurately recorded. Therefore, it's inadmissible.
What's the document?
It's the police report that the defendant wrote herself.
Okay, overruled.
Now, in the report, the defendant states that she witnessed several individuals spraying the fire with beers. Isn't that true, Mr. Bradshaw?
I believe so.
And you acknowledged that several other protesters also attempted to throw away the evidence of their open container violations, correct?
Your Honor, outside the scope of his testimony.
Response, Your Honor. Yes, Your Honor. This is in the witness's deposition. This is not outside the scope of the witness's testimony. They stated such in the deposition. I'm simply bringing it out in cross-examination now.
Overruled.
Mr. Bradshaw, as I stated, you acknowledge that several other protesters also attempted to throw away evidence of their open container violations. Isn't this true?
I don't know if I stated that.
Is it your testimony today that you didn't state so in your deposition?
I thought you were asking about the police. I'm confused right now. Can you ask the question again?
Yes. In coming to your conclusions, you believed or you acknowledged that several other protesters also attempted to throw away the evidence of their open container violations. Isn't this true?
Are we still talking about the police report, or are we talking about my deposition now?
This is your conclusion based off of that police report. So within the deposition.
Well, my conclusion on the police report was that Corey Jacobs was arrested based off probable cause for having an open container. The police report said—
Bradshaw, that's not my question. My question is that you acknowledge several other protesters also attempted to throw away evidence of their open container violations. Yes or no?
So if I'm understanding, could you repeat the question?
Yes. You acknowledge that several other protesters also attempted to throw away the evidence of their open container violations. Yes or no?
They might have.
A yes or no, Mr. Bradshaw. If you need me to refresh your memory with your deposition, I can do so.
I believe so.
So that's a yes?
That's a yes.
Yet the defendant only approached these individuals to investigate, not arrest, correct?
I believe Officer Riker approached Corey Jacobs, yes.
Before the defendant recognized Miss Corey Jacobs, she approached these individuals to investigate, not arrest, correct?
I believe Officer Riker approached the scene. I don't know what you're trying to ask.
I'm asking, when she saw these other individuals, she approached them to investigate, not arrest them, correct?
Well, as far as my review, she went straight to Jacobs for the arrest.
Mr. Bradshaw, I apologize if I'm making this confusing. Before the defendant saw Mr. Jacobs, and after the defendant arrived at the scene, the defendant saw several individuals spraying the fire, as you testified earlier, and she approached these individuals to investigate, not arrest, correct?
I believe she approached to investigate and then arrested, yes.
Just to investigate, according to her police report, correct?
I believe Officer Riker approached to arrest.
Arrest these individuals?
Yeah, the people violating the ordinance.
Is it your testimony today that according to the police report, she approached these individuals to arrest, not investigate?
Objection, Your Honor, hearsay.
Response?
Yes, Your Honor. This is still referencing the police report as you ruled earlier under 801 D2A. This is still admissible party opponent statements.
May I respond?
Yes.
The content is still inadmissible. Dr. Bradshaw cannot speak to the officer's actions. They should have asked the defendant on cross whether or not these actions and any of the statements in this document are true.
Overruled.
Let me re-ask this one more time, Mr. Bradshaw. The defendant decided to make an arrest, or is it your testimony today that the defendant approached these individuals to arrest, not investigate?
Officer Riker approached these individuals, and then she conducted the arrest of Corey Jacobs. I don't know the specifics of, I can't speculate to what, specifically her intent was.
Would you like me to refresh your memory based off of her police report?
If you could.
Yes, Your Honor. Your Honor, at this time, I'm approaching opposing counsel and the witness in turn with what has been previously marked as the defendant's arrest report, specifically page 56 of the case packet.
Okay.
Mr. Bradshaw, do you have it in front of you, or would you like me to screen share?
Could you please share that with me?
Yes. Can you see that? Can you see that, Mr. Bradshaw?
Yes, I can.
Okay. Please read quietly as I read aloud. As I approached the parking lot blaze, I noted several individuals who appeared to be spraying the fire with beer. In that open containers of alcohol are prohibited there under the Overton Code, I approached these individuals involved to investigate further. I read that correctly, didn't I?
Yes, counsel.
And then it was only after the defendant noticed Mr. Jacobs that she began to conduct an arrest. Isn't this true?
Well, Officer Riker had probable cause to conduct the arrest. Corey Jacobs had an open container of alcohol on him.
The defendant only decided to make an arrest after she recognized Mr. Jacobs, correct?
Well, once she got there.
Mr. Bradshaw, a simple yes or no.
I'm sorry, could you ask a question?
Objection, Your Honor.
What's your objection?
I'd like to argue this whole line of questioning is outside the relevance and outside the scope of this investigation. Dr. Aaron Bradshaw was hired only to speak about probable cause as it pertains to Corey Jacobs' arrest. Don't believe he can say anything pertaining to the potential arrest of other individuals. Dr. Officer Sandy Riker's belief that she could have arrested other individuals.
Response, Your Honor.
Yes.
Now, this is very relevant to today's case. Based off of this witness's review of the police report, they concluded that there was probable cause. However, I'm bringing up facts that might show otherwise, that there was perhaps an ulterior motive. Now, this is very relevant in today's case as it does prove facts in today's case to be more or less likely, specifically what the plaintiff is alleging. If Officer Riker only was intending to investigate other individuals, but then decided to arrest Mr. Jacobs once she recognized Mr. Jacobs, this goes to show that there might be an ulterior motive besides simply trying to do her job.
Overruled.
Mr. Bradshaw, yes or no, the defendant decided to make an arrest once she recognized Mr. Jacobs?
Well, I can't speak to when she decided to make the arrest. All I know is that there was probable cause to make the arrest of Corey Jacobs.
So yes, Mr. Bradshaw.
Like I said, I can't speak to, whether she decided to or not. That's something that you should have asked her.
The defendant didn't call for backup to arrest anyone else that day, right?
Not that I'm aware of.
The defendant didn't call the fire department to put out the fire, correct?
I wouldn't know.
Did any of the material you reviewed indicate that the defendant called the fire department to put out the fire?
I believe there was, when I reviewed my material, there were other officers, but I don't know as far as what I saw in the material. I didn't see a fire department called.
You're aware the defendant had a partner on patrol with her, right?
I believe so.
Yet the defendant didn't instruct her partner to make any arrests.
Like I said, I'm only here to speak on the probable cause of Corey Jacobs' arrest. I don't know whether that's something that you should have asked Officer Riker.
Mr. Bradshaw, you reviewed all the material in today's case, correct?
Yes, I did.
You came to a conclusion in today's case.
Yes, I did, that there was probable cause to arrest Corey Jacobs.
So based off of that material, did the defendant instruct her partner to make any arrests?
I don't know whether she instructed or not. I don't believe that was in the material I reviewed.
Now, you don't conclude that Mr. Jacobs drank a beer at all, correct?
I concluded that Corey Jacobs had an open container and that there was a fair
Mr. Bradshaw, that's a yes to my question. Mr. Jacobs didn't drink any beer.
Mr. Jacobs had an open container, or it was fairly reasonable for Officer.
Mr. Bradshaw, that's not the question I'm asking. Opposing counsel will have the chance to go up and ask you these questions, but I'm asking you, did Mr. Jacob drink any beer that night?
Objection, Your Honor.
What's your objection?
Is beyond the scope of what the expert witness was asked to review. They were only there to render an opinion on probable cause, not determining the probability or likelihood that Mr. Jacobs was doing an act or not doing.
Response?
Yes, Your Honor. If opposing counsel is stating that the expert was only retained to form a conclusion that there was probable cause, we can move on. Otherwise, we can delve into the facts that this expert reviewed and explore the different alternatives that this expert did not end up using in his conclusion.
Overruled.
Yes or no? Did Mr. Jacobs drink any beer?
Objection, Your Honor. The
What's your
probable
objection?
witness is attempting to prove is possession of an open container, which is the claim under which Mr. Corey Jacobs was arrested. The line of questioning of whether or not he was drinking a beer is irrelevant to the establishment of probable cause.
Response.
Your Honor, this is very relevant as we've listed throughout trial today, there were several individuals drinking beer. Now, if Mr. Jacobs was not one of those individuals drinking beer, and as opposing counsel claims, the officer was simply trying to do her job and prevent people from breaking the law, then why did the officer not arrest anyone else who was drinking beer, but arrest someone who wasn't? This goes to the plaintiff's theory that there was an ulterior motive and is very relevant in today's trial.
Overruled.
Your Honor, may I ask that the witness be instructed to answer in a yes or no fashion to save the court's time?
No, I think that's your job, counselor.
Yes, Your Honor. Yes or no, Mr. Jacobs did not drink any beer that night.
Counsel, I don't know if Corey Jacobs was drinking beer that night. Corey Jacobs.
So you don't know, Mr. Bradshaw?
Counsel, I was brought in to testify on the probable cause.
Do you not know? Yes or no?
I was brought in to testify on the probable cause
Mr.
of
Bradshaw.
Corey Jacobs.
Your Honor, at this time, I move for non-responsive. The witness is not even answering my yes or no questions.
Yeah, Mr. Bradshaw, please answer the question. If you know, say yes. If you don't know, say no.
I don't know.
Thank you. All you conclude is Mr. Jacobs held a beer at one point, right?
Correct, in violation of the Overton Municipal Code.
So as you stated, he's breaking the law, right?
Correct.
So Mr. Bradshaw, if someone sees an open beer can on the floor next to a trash can, they would be breaking the law if they picked it up to throw it out, right?
Counsel, it's the totality of the circumstances in that situation.
Mr. Bradshaw, the circumstances I presented to you, yes or no, would they be breaking the law?
Counsel, that is an entirely different scenario. In that scenario, you would have to consider all the other relevant, the totality of the circumstances in that scenario. Now, if in your scenario nobody else is drinking, then perhaps, but I can't give you a complete answer if you don't give me a complete picture. In this scenario,
Mr. Bradshaw, I'll give you a complete
surrounded
scenario.
by a lot of people drinking.
Mr. Bradshaw, an officer arrives to a scene to see someone picking up an open beer can on the floor and throws it in the trash. Can that officer arrest them?
Like I said, counsel, if you put it in the totality of the circumstances, then if there is
Your
reason.
Honor, at this time, I move as non-responsive once again. This witness is not answering a simple yes or no question.
Yeah, that's granted, but let's move on, counsel. I think
So
you got
can
the
I just
answer
get-
you're looking for. I think
Yes, Your Honor.
we understand the point.
Yes, Your Honor. At that point, I have no further questions for the witness, and I pass the witness.
Redirect.
Yes, Your Honor. Dr. Bradshaw, may I ask you one more time to go ahead and read the statute that Corey Jacobs was found in violation of?
Of course. So the statute is Overton Municipal Code Section 1433-1. It states the use and possession of open alcoholic beverages is prohibited in areas such as a beach and adjoining access, like the one where Corey Jacobs was arrested.
So does possession alone violate that law?
Correct.
There's no need for Mr. Jacobs to have been actively drinking at the time he was seen?
No, there is not.
Officer Riker had probable cause to assume a crime was being committed by seeing Mr. Jacobs in possession of a beer, correct?
Correct.
That'll be all, Your Honor.
Defense counsel, do you have any other witnesses?
No, that's our last witness, Your Honor.
Is the defense resting?
Yes.
Any motions?
Your Honor, at this time, the defense would like to make a motion constructively outside the presence of the jury.
You may proceed.
We would like to re-urge our prior motion for judgment as a matter of law. We again believe that the plaintiff has continued to fail to provide any sufficient evidence or connection to support its case that the chilling of the plaintiff's First Amendment rights were a motivating factor for the arrest on October 26th.
Response?
Yes, Your Honor. Again, I believe we've presented more than a scintilla of evidence to have a reasonable juror believe that the killing of Mr. Jacobs' speech was the motivating factor for this arrest. In addition to the statement made by the defendant to Mr. Jacobs that he shut his mouth earlier, it's also been established that he was the only person arrested out of almost a crowd of 500 that for this particular law. And this is the only individual who'd spoken to her the night before. Again, we think that these facts in and of themselves could lead a reasonable juror to believe that his speech the night before was a motivating factor for his arrest.
Okay, the motion is denied. Any other motions?
That'll be all, Your Honor.
Okay, it is 7:55. Let's come back at 8:05. Give 10 minutes. Is that okay with everyone?
Yes, Your Honor.
All right. Looks like we're still waiting on defense counsel.
Are we missing more people?
Okay. Okay, we've got everybody. All right, we ready to begin?
Yes, Your Honor. Plaintiff's ready to proceed to closing arguments.
Okay, please proceed.
May I reserve 2 minutes for rebuttal?
I'm sorry?
May I reserve 2 minutes for rebuttal?
Sure.
May it please the court? I bet you wish you had shut up when I was talking to your friend yesterday. Those are the words of Officer Sandy Riker to Corey Jacobs. How Corey Jacobs knew that he wasn't being arrested for violating a minor alcohol ordinance. Now, Corey Jacobs, a man who was handcuffed, shoved in a cop car, driven to jail, and charged, wasn't being arrested because he was one of many people around beer cans on the street. He was being targeted by the defendant, an officer of the law, for having the audacity to exercise his First Amendment right to free speech, a right that we are all guaranteed under the Constitution. Because you see, that First Amendment right, it does more than let us wear political shirts or make off-color jokes. It empowers citizens to speak truth to power, who know that when they're speaking to a government authority, they're free to speak their mind without fear, without retaliation. Now, the night of October 25th, 2019, the defendant showed up at Corey Jacobs' apartment. She didn't tell anyone why she was there, and she began to demand Jerry Hoffman turn over her cell phone. That's when Mr. Jacobs exercised his First Amendment rights to protect Jerry Hoffman by telling her that she had a right in the Fourth Amendment to be free of a warrantless search or seizure, a right that the defendant certainly wasn't informing her of, likely because, as she admitted on the stand today, he did not have a warrant for Ms. Hoffman's cell phone. That night, Corey spoke truth to power. And Officer Riker told him to shut his damn mouth. The very next day, he was in handcuffs, courtesy of the defendant, for violating an alcohol ordinance, a minor offense that a police officer can arrest and jail someone for, but as the defendant stated on her direct examination, doesn't have to, much like jaywalking or a child missing too many days of class, other minor crimes that a police officer can put you in jail for if they feel like it. Next day, Officer Riker wants you to believe that her actions were entirely unmotivated by her feelings towards Mr. Jacobs. She took the stand earlier and she told you that she was called to the parking lot when she arrested Mr. Jacobs for two reasons. Because there was a large fire and because there was a crowd getting out of control. And yet, the defendant didn't make any arrests for arson, didn't make any arrests for disorderly conduct. She looked out at a sea of people with beers in their hand drinking, and she wants you to believe that the only one she managed to catch was Corey Jacobs, the very same young man who decided to speak up to her the night before. And not only was Corey Jacobs the only person the defendant arrested that night, he's actually the only person at a rally of almost 500 people who were arrested for violating this minor alcohol ordinance. Members of the jury, does that seem like a coincidence to you? Now, we're here today because Mr. Jacobs' right to free speech was violated by the defendant's retaliatory arrest. In order for us to prove that his rights were violated, we need to show you that four requirements have been met. That the defendant acted under the color of law, that Mr. Jacobs engaged in free speech, that the defendant took action against Mr. Jacobs, and finally, that Mr. Jacobs' speech was a substantial or motivating factor behind that arrest. And we need to show you these things by a preponderance of the evidence. Earlier, my co-counsel spoke to you about this. The legal standard that means more not likely than not. And as my co-counsel described in opening statements, these can be thought of as scales. And every fact in this case tips those scales to one side or the other. Now, if you feel that those scales have been tipped over by the facts to the plaintiffs, you will find that the defendant was liable for violating Corey Jacobs' rights. And it's been shown to you numerous times, and the defense acknowledges that the Officer Riker was exercising her power as a police officer when she placed Corey under arrest at the beach. And members of the jury, whether Officer Riker wants to admit it or not, Corey Jacobs has a right to speak to his roommate. He has a right to speak to her as a police officer, even while she's doing her job. Defense wants you to believe that Mr. Jacobs was interfering with an investigation, which they all acknowledge that he knew nothing about at the time. And yet she didn't charge him. And Mr. Jacobs didn't force Ms. Hoffman to withhold her cell phone. All he did was speak his mind freely in the presence of a police officer. This is one of the very types of speech that the Constitution seeks to protect. Now, did the defendant take action against Corey? That much you've also learned. The defendant placed Corey Jacobs and no one else under arrest for violation of an alcohol ordinance, while letting more than a dozen wrongdoers, who both she and her defense expert acknowledged were openly drinking beer, go free. Because none of those people had ever spoken up to her before. And finally, was Corey's speech a substantial or motivating factor behind this arrest? Now, the defendant may want you to believe it was merely a coincidence that the only person she arrested, the only person at all arrested for this violation, is the same person who spoke up to her. But when she said, "I'll bet you wish you would shut up when I was talking to your friend yesterday," it becomes extremely clear that Corey Jacobs' speech to her the night before is the factor that caused this arrest. You've heard testimony that makes it clear that at every step of the defendant's interactions with Mr. Jacobs, she stifled his speech, she threatened him, and the very next day, the moment she recognized him, she slapped him in handcuffs. And the defendant, she got on the stand today and couldn't even definitively tell you that she's always followed proper procedures, only that she tries her best. She said the most important thing to her is the community, and yet she didn't arrest a single person that she saw drinking beer openly. That the crime of holding a can in his hand was more serious to her than people spraying beer into the fire or drinking on the beach in open violation of this ordinance, which she is so very concerned about enforcing. Now let's talk about the defense expert, Mr. Bradshaw, who couldn't tell you if he relied on any peer-reviewed methods of practice, who didn't know what was in his deposition or what the police report that he reviewed even said, who refused to speak to the opinion anything except what he concluded, which was that the defendant acted appropriately. In fact, he could only and would only speak to the opinion he was hired to give. And not just once, but by his own testimony, he's been hired more than 27 times to testify. All he could tell you was that Officer Riker was in his right, and he reread the municipal code. And when I sit down, the defense counsel is going to come up here and speak with you. Just like you're in trial, they're going to try and tell you that the defendant had probable cause to arrest Corey Jacobs. And that because she had this probable cause, her actions can't be retaliation. What they fail to mention is that probable cause is not why we're here today. Members of the jury, the reality is whether or not the defendant had probable cause to make this arrest is not relevant. Having probable cause does not allow an officer of the law to violate the law, and it doesn't give an officer permission to violate an individual's rights. It's been made clear to you just how easy it is for an officer to establish probable cause. But just because you have probable cause to arrest someone, it does not excuse you from the consequences of your actions. It doesn't excuse the violation of Corey Jacobs' rights. The fact is, the defendant thinks that she can create probable cause, she can get away with retaliating against Mr. Jacobs. Unlike Mr. Jacobs, who used his right to free speech to help his roommate, the defendant is trying to use probable cause to help herself get away with silencing him. Don't let her. Thank you.
Defense.
Greetings, Your Honor. May I share my screen with you and the jury, please?
You may.
Thank you. Hold on. All right, did that work? Can everyone see
No.
my screen?
No.
Didn't work. Okay, hold on. My computer is frozen. There we go. Okay. Can everyone see my screen?
Yes.
No. Yes. Good. Opposing counsel, can you see my screen?
Yes, I can see it now.
Awesome. Awesome. Members of the jury, thank you all for meeting with me today. This case is not as difficult as the plaintiffs are trying to make it seem. And just by starting off, I want to go over the statute that you all have with you today that says prohibited use and possession of alcoholic beverages. The use and possession of alcoholic beverages is in any open bottle, can, or container is prohibited in any public place or area administered by the city of Overton. And if we scroll down, it says arrestable offense. Overton Municipal Code 417.10. No person under the age of 21 is permitted to buy, possess, drink, or consume alcohol in any manner. Persons guilty of such conduct are subject to arrest and citation for a Class A misdemeanor under the Overton Municipal Code. Have I stopped sharing my screen?
Yes.
Awesome. As I just started off by saying, this case isn't as difficult as the plaintiffs are making it. It's actually really simple. This entire case is about a police officer doing their job. That's it. And the plaintiffs know this case is simple. That's why they need you to believe that this is somehow about freedom of speech or retaliation or a cop going rogue, but really none of that matters. This isn't about drinking, it's about probable cause. This case is only about probable cause. That's it and only it. Did Sandy Riker have probable cause when she arrested Corey Jacobs? Objectively, did she act as any other police officer would have acted in that exact same situation? And that's a pretty easy question to answer. I mean, you guys heard all the facts. Officer Riker arrived to a large and rowdy protest. She saw fire and people drinking, and she looked down and saw Corey Jacobs with an open container, to which Corey Jacobs even admitted he had a can of beer. Plaintiffs don't want to admit that this case is easy because that's not good for them. They want to confuse you with this First Amendment issue and silver cans and all sorts of irrelevant facts that really don't matter. Plaintiffs are trying to suggest now that probable cause doesn't matter, but that's not what they alleged at first. That's not what's in their complaint. In their original complaint, they said that Officer Riker had no probable cause for arresting Jacobs. But now that probable cause isn't on their side, they want to move the goalposts a little bit. Probable cause is why we are here today. That is it and only it. If you're found with an open container of beer at Overton Beach, that is an arrestable offense. Those are the laws. We just read them to you. All Officer Riker needed was enough evidence to suggest that Corey Jacobs was indeed holding a can of beer to make the arrest, and she did that. And ask yourself this question. Have they given us any information or any evidence to controvert that fact? I mean, they told you about the standard and preponderance of evidence, but what exactly have they placed on the scale to deny that Corey Jacobs was holding an open container? They're so focused on trying to confuse you about what this case is about, they haven't mentioned anything to deny the existence of probable cause, have they? Everyone in this case agrees on the facts. You heard Corey Jacobs admit to holding a can of beer. You heard Officer Riker admit to seeing Corey Jacobs holding a can of beer. Moreover, you even heard expert opinion from Dr. Bradshaw conclude she believed Officer Riker had probable cause. Have plaintiffs introduced anything to deny that? In fact, the only thing the plaintiffs have done to deny the existence of probable cause is now attempt to suggest that, well, Corey Jacobs didn't really know what was in the can, but does that even matter? And do you believe that? I mean, think about it. This is a 19-year-old kid in law school, really smart kid, and he knows there are two types of cans at this beach. One of them, we don't know what it's going to do to the fire, but the other one is definitely going to make the fire get bigger. And he said, I wanted to help put the fire out, so he doesn't check and he just tosses one of them into the fire. Does that make sense to you? Probable cause is the only reason we're here today. Corey Jacobs committed an arrestable offense, and then he was arrested, and then he got embarrassed. And he got embarrassed because he got embarrassed, he sued the police officer. Now Corey Jacobs is saying that Officer Riker retaliated against him, but who's really here today because of a vendetta? The police officer who thought nothing of the interaction, or Corey Jacobs and his lawyers who don't think probable cause matters anymore. Corey Jacobs is someone who wants to be a civil rights attorney and someone who is involved in protests and stands up for everyone's rights. It's why he was so eager to insert himself into the police investigation that night. Remember, he approached Officer Riker twice that night. And if it's truly about retaliating, then why didn't she just arrest Corey Jacobs that night at the party? Because it's not. Corey Jacobs' rights were not violated, and he knows that. He's here today trying to make a point. He even said he was angry. He took this personally, and he's trying to be that civil rights attorney right now and advocate for justice. The problem is the facts are not on his side. I'd like to thank you all for helping us with this trial today. You all have an important job in determining a fair outcome for both Officer Riker and for Corey Jacobs. You've heard all the testimony, you've seen all the evidence. However, this is not a complicated issue. Probable cause. Remember that. You know Officer Riker acted as an objectively reasonable police officer when she saw Corey Jacobs holding that can of beer. She should not be punished for doing her job. I ask you now to return the only verdict that the facts support. Thank you.
And this court,
You may proceed.
ladies and gentlemen of the jury, as much as I like to sit here and listen to opposing counsel mistake Corey Jacobs' testimony, he didn't actually ever admit that he was holding a can of beer. Opposing counsel even admits that he didn't know what was in the can. And while opposing counsel spoke multiple times during his closing about how important it was that he was violating this ordinance by holding a can of beer in his hands, he then turns around and asks you, does it even matter? Does it even matter? Opposing counsel just asked you that. I wrote that down and circled it. Does it even matter? Well, it clearly didn't matter to the defendant because she saw multiple people drinking beer around her and she arrested none of them. Not a single one. She didn't make an arrest until after she recognized Corey Jacobs. There's one thing that opposing counsel and I agree on. This case is very simple. And it is about whether an officer did her job. Because if the defendant had done her job, she would have arrested any of the numerous people that she actually saw violating this law. And instead, she chose to arrest one person, Corey Jacobs, not for violating an open container law, but because he had the audacity to speak up to her the night before. Hold her accountable to her actions. Thank you.
All right, guys. So we're done with the case. Super good job. We'll start critiques, but I've been talking this entire time, so I'm gonna make one of these other judges give critiques first. I'm gonna go last.
And
Who wants to
before
go?
real quick, Alex, before we even
Sure.
start, can I have the judges in the round text me who they thought won the round, and then
Yes,
give you some feedback. But good job, everybody.
sure. Yeah, let me do that.
And look, Janan popped on first, so Janan can talk first. You're on mute, Janan.
I said, all right, I'll go ahead and send my text message.
Okay if I eat my burrito?
I think that that's probably fine. It's been a very long day for all of you, and we know we did not give you much time between the last round and the
I'm
start.
so hungry and it's cold, but I still want it.
I know it has been a beast of a day, guys, but I'm so proud of all of you. Like, seriously proud of all of you with what y'all have accomplished in literally, like, what, 10 days time? Amazing. Absolutely amazing. So, Janan, whenever you're ready.
Okay, and how did you want me to give like maybe like one good like critique for everybody, or general things, or go through each
General things that, since they will, most of them will never do this case ever again. So general advice, if some of the lawyers have, or some of the witnesses are exhibiting tics that we need to correct,
Okay.
feel free. But don't worry about talking about specific aspects of the case in terms of the merits of the case, because most of them are never doing this case again. They're going to move on to some other case. Maybe your case, Janan. Who knows?
That's true. Okay, I'll do, I guess, general as we go through the trial, because that's kind of how I took my notes. As far as openings, really good job, guys. For plaintiff, and this is a personal preference. I think people will disagree with this potentially, but as far as going into like the law and the burden of proof and opening, I'm not sure that I like that. And the reason for that is if this is a jury trial, which, you know, I think we presume all of these are, you will have already done that in voir dire. Like you'll have already hit on the law, and you'll have already hit on the burden of proof pretty extensively. I know that there is no voir dire in mock trial, but I still also think that if you're taking time to do that in opening, you're using up time that you have where you could be persuasive in telling a story. Again, I think that's just me, but, or that could just be me, but that's what I think. You want to always be persuading. And if you are going to hit on the law, I think maybe you would like touch on what the specific issue is that you think is going to come up. So it's not like a couple minutes of things that are a little more dry. But again, I think reasonable minds will disagree about that. So defense is opening. I thought you did a good job. I liked your theme of the case. I didn't write it down, but I remember I wrote down that I liked it. I think you want to be careful with talking about and characterizing this as being simple. And really that goes for any case because it's a trial case because, again, reasonable minds are going to disagree. And so you don't want to call it simple because usually it's not going to be. I wouldn't touch on what the plaintiff is going to say generally. And I saw this a lot throughout the whole tournament in something like opening. There are moments to do that, but this is the time to tell your story. And if you're already sort of getting to the place where you're refuting what you think that like the other side is going to say, it sounds defensive, like if you have something to defend. Again, that's a style thing, so people might disagree. Also, I saw this a bunch. I don't like thank you at the end of like openings, directs, or after rulings. It just sounds kind of, I don't know. It's not wild about it. Okay, so for the witnesses. Okay, so this was a big thing also I saw throughout the trial, and this kind of applies overarching. I think you've got to be really careful when you're sort of waving the, or with the righteous indignation. I think that this case was, I think you could go, like, I could see both sides of it. And so I think you want to be really careful when you're talking about a police officer is bullying this law student, that they hassled them. Like, I think that if this were real life, you absolutely would have a lot of people who disagree with that. And so when you're sort of using that strong language and people don't agree with you, I think it can harm your credibility and could put jurors off. Especially on something like this, where he really probably could have taken the phone, guys. Like, you don't need a warrant to take the phone. You need a warrant to search the phone. And he's basically saw that as, he knows that that's evidence of a crime. He probably could have taken the phone without a warrant. Let's see. Okay, and I don't remember who this was for, but I think it maybe been when cross starts. Like, you don't want to start off like, how you doing? Also, if this is federal court, which mock trial tournaments usually are, never first names, always Mr. and Miss. Make sure that you're listening to the witness. Like, I think this is specific to cross because there were some things that came out on direct that I think you could have used. So you want to make sure if they give you something really good that you're not just sort of sticking to your script and I know you guys didn't have as much time with this, but really listening and making sure that you are responding to what's actually said on direct. Don't concede anything. You can withdraw an objection. I think there were some things in there that I wouldn't have withdrawn either, but you never concede. Redirect, unnecessary. I think all the redirects in this were not helpful but harmful. Redirects you should only use if you're absolutely bleeding out, like something just like terrible just happened and you're like, oh my God, the ship is sinking. Because generally they don't work. Yeah, I wouldn't ask about like, how's law school going? And that kind of goes for all it's definitely important to personalize your witness and to get into some background, but I wouldn't ask questions like, how are you doing? How's law school going? I think it's not really relevant and isn't I think your jury is going to be like, come on, like we're taking time out of our lives to be here. Get to the point. Again, personalization is different. Absolutely should personalize them. I wrote for cross. I wouldn't ask things like, you want this court to believe, unless it looks like they're blatantly lying. Because again, reasonable minds can differ. So if you're like, you really want this court to believe this, and the jury might be thinking, well, I believe it, so just be careful with strong language unless it's absolutely warranted. Now, if they're getting up there and they're lying through their teeth left and right, and you caught them and they still don't want to admit it, like, okay, but be very careful. Okay, so just briefly, the cross of the next witness, I wrote like dial it down a bit. And I think what I was referring to was, again, the rhetoric that's just really inflammatory, because you're going to have jurors that don't agree with that. And so you've got to make sure that everything that's coming out of your mouth is going to be well received by every person on that jury, even the ones that disagree with aspects of what you're having to say, because there will be people that do. Voir dire, not voir dire. Okay, and this is another big one too. I saw this again throughout the tournament. There was a lot of like attacking the people's formal education, and the vast majority of the jurors that you're going to try cases in front of do not have extensive formal education. And so I got the point you were trying to make. You were trying to say like, hey, you're here testifying as a witness, but I wouldn't frame it in like, you don't have a PhD, you don't have a law degree, because it just comes off like elitist a little bit. I wrote no redirect. That was harmful and not helpful and cumulative. Closing, I think again, it was a little too, this was a bad cop, this was a good little law student. Like, y'all, like this is literally like a serious felony investigation, and he's just like popping himself in to weigh in. And again, like the officer could have taken that phone and probably should have taken that phone, and he did not need a warrant. So it's fine, because I don't think that that's determinative of the facts. It's just, if you're just over here just saying this cop is bad, and this was a good little law student, like I think that there's a lot of people who disagree with you. Defense close, I would have liked to have seen you do a little more using the jury charge. And I think that might have maybe changed some of the directions that you took the closing in, as far as which aspects of the law you were highlighting. So I'd encourage you to kind of look at the jury charge and work backward, because it's what's in the jury charge ultimately that you're going to have to end up arguing at the end, and what you're going to have to prove. So I'd start with that, make sure that that's what you're structuring your argument and your evidence around, and I'd use that in closing. Rebuttal, I thought there was a lot of stuff that was really strong about that, but you want to be careful. I think it crossed the line a little bit sometimes into snark. I was like, so don't be like overly, like, just be right. And you were right, I think, but sometimes with a little extra. So, but overall, I thought you guys did a really
common feedback. I hate to say.
Do what? I'm sorry.
The common feedback. I hate to say. Working on it.
That's okay. Well, it's something that you can absolutely work on, and it takes practice. But overall, I was super impressed. Like, you guys did such a good job. And I know I kind of hit on the stuff that you guys need to work on, but I would have lots of good things to say in praise. I just figure with limited time and lots of judges, I wanted to hit on a few things I think you guys could really honestly make better tomorrow going into the next competition that you're preparing for. So good job, guys.
Thank you.
You're welcome.
Go ahead, Mark. You're sitting there.
Well done, everybody. I thought that was very impressive and very, well-deserved for all of you all to be there in the final round, and to, have come this far with such a limited amount of time to do what you do and to pull it off. I think it's just fantastic. And it makes me very hopeful for the future of mock trial, seeing you guys, already so good with such little time to prepare. I'm going to keep my comments pretty brief and focused on one thing in particular, because this is one thing that I'm still learning about, and one thing that, as I'm judging all of these rounds in this intramural tournament, I'm starting to learn kind of how important these small details are. In particular, and this is something that I told the Britney Spears team the last time I judged, because they were in that round, and it's some important specifics about the use of Zoom in mock trial. It's something that's never been done before, at least in the times that I've been doing mock trial, and I've been doing it since high school. And first and foremost, something I already told the Britney Spears team, but it's something that I think is worth repeating. When you want to make eye contact, you don't actually look at the people's faces on the screen, you look into the webcam, and you can make eye contact in that way instead of looking at the people's faces on the screen. And it's going to make a difference, because it makes a difference in real life when you make contact. And by looking into that small little webcam, you can make eye contact with every single person who is on your phone or on your laptop. That said, and some of you guys did a great job of doing this, because we can't see your body, because we can't see your hands. If you are going to use them, get them into frame. It doesn't make sense to be doing hand motions that are like at the periphery. So if you have like a good center and you can put up numbers and do things like that, make sure that it's all in frame so that, you know, it actually adds something and it makes sense. A counterpoint to that is make sure that you have a good background. People are going to be looking at every single thing that's in your frame, the wall color, the chair color, like TV, poster, you know, whatever sort of furniture you have. So it may make sense to find a designated place in your home or apartment or wherever you are that is going to be your mock trial like seat. And it's got to have the proper lighting. If you have a round that begins in the afternoon and it ends at night, and the lighting's going to change, you got to have a good, you know, something that's not distracting. And that kind of goes, we normally didn't have to worry about that. The only thing that we had to worry about was what we wore as being distracting or not. Now it's what is in the room, what is in your camera that could be distracting. And some of you guys have already done like a really good job of, you know, setting up a non-distracting environment to do your, you know, your Zoom mock trial from. And the third sort of Zoom rule that I've learned, which seems like a simple one, but it's an important one, is make sure that your webcam is clean before you start. You know, I feel like judges will subconsciously score people down because they have fuzzier picture or because there may be a smudge in their camera. And we don't really realize that, you know, until it's too late. So at the very least, clean off your webcam because it's projecting your image. Normally we would just see you in real life, but because we're seeing your image, we want to see something that is as clear and crisp as it can be. And if you can afford it, maybe even consider investing in a really nice sort of high def webcam. If that's something that's already in your computer, laptop, great. If that's something you already have, great, utilize it. But like I said, at the very least, make sure that your little webcam is clean. Otherwise, those are my little Zoom tips that I'm learning as I go along. Hopefully I get to work with more of you folks in the future and do some more substantive things, but well done.
Real quick on that note, can I just remind y'all that there's a video setting that you need to make sure is on where it will put you in high def. You need to make sure that if you haven't checked yet, that is clicked on for you so that you are as crisp and clear as possible.
To add on to that, Judge, there is also a setting that cleans up your appearance. I'm sure whoever's used Zoom enough knows that there's a touch-up setting. So it kind of clears up your face, and I think it may even be a little bit slimming. I don't know if that's something worth using, but something worth trying out to make it, you know, just to see if it helps any. Just thought I'd throw that out there.
I'm interested.
Alex, did you want to go? Or Monica, are you still on the call?
I am. All right, I can go really quickly because I think that y'all have heard so much feedback throughout this entire competition. So I just want to give y'all like 5 seconds each person. So Youssef, I think that you are very like technical and you know your impeachment and you know your packet. And I need you now to bring you, right? Like you are like, I think that sometimes you get so like, no, I will get him to admit this thing, that we lose the bigger picture, right? We ended up having I think it was Bradshaw. Yeah, Mario, you seem sweet. You were really giving him a hard time, which is what people are gonna do, because that's their purpose, right? Their purpose is to goof you up. But if you lose track of your time, I think we ended up using 22 minutes, then we lost you, and now we're just in this quibble match, and we're not winning the jury anymore, or the jury being the judges, right? We're losing that. So I want you to think about bringing you to it, getting clean points, and then knowing when to stop, because it was enough, yeah? Who else we have? Alejandra, you seem sweet, but when you need to, you bring it. You and Mario were so funny, because I told this to Mario when in his round. I'm like, Mario, you're just so sweet. I want the fire. And then I saw him as Bradshaw, and I was like, that's what I'm talking about, Mario. Bring that. But as an attorney. But you did a great job, especially when we were arguing Draper. I think bringing it back to all this training experience. I thought that your open was great. I think, and actually, I'm going to say this to everyone, because these are kind of my big general points, is I want everyone, I think everyone did a really good job on this round, because y'all are the finals. Y'all did it, like y'all got to the top of the top. Y'all do a really good job with varying your tone, right? But there's more to it than just varying your tone. You need to vary your pace. You need to vary your volume, right? Because those are the things that are bringing attention beyond just like da-da-da, da-da-da, da-da-da. I'm like, no. I also want, for example, let's use Mycal's closing. You said like, do you really believe that, right? But you said it in the same tone as everything else you were saying, which was like fire, fire, fire. That was a great time to slow down and be like, do you really believe that though? And also just like using that, just not so much always fire and brimstone, because I think that that's what we always see on TV. So we think that everything needs to be attack, attack, attack. And I think that y'all should really use the chances to vary in those ways. So Alejandra, I think that you did a great job throughout. I want to see more of that kind of variation though, because and I think that when you are arguing off script, you did it more. So I want you, again, it's bringing yourself. Billie, sorry, I'm like, I have so many good things. I'm like, how do I sum up Billie? You as well are very meticulous. You're very thorough. I loved your close just because I felt like we were doing story and bringing your story in the way that you wanted to. Good list of your elements. But again, my favorite part was the rebuttal, because the rebuttal, again, wasn't this like scripted thing that you needed to follow. It was responding and bringing your personality to it. One of the things that was hard, because of Jackie, it was hard, is that she came in as officer as so sweet. She was just like dripping this sweetness. And this is always something that I struggle with, because I am a pretty fiery human, is crossing someone that is so sweet, but you need to cross them and you need to get that point. Like balancing I have to be a little sweet back because I have to be the more reasonable person, but also just crossing her with those points. So I think that as you go into competition, getting that fine-tuning that balance between like, I don't want to be a bitch, especially when, I'm sorry, I just said bitch on this. That's terrible. But I don't want to be that, right? I want to be both things. And I think that you'll get there, but you did a great job. And then Mycal, you have all the enthusiasm in the whole world. I loved that I got to see that in your clothes, right? Is that you have like all the fire there. I wanted to see that throughout. I know that you struggled, especially with Sandy, because you want to lead, you want to be controlling the narrative in exactly the way you want it to be. So just working on that, but that's just, I want to lead all the time. And so just mastering your directs so that you don't draw those objections all the time. But all in all, I think all of you did wonderfully. I can't wait to work with some of you, hopefully this fall. And if not, then in the spring. So good job, guys.
Boylhart, do you have anything you want to say? I know you talked a lot.
Yeah, I think following up on what Monica was saying about tone, pace, fluctuation, all of that in real mock trial is so important. That's an important, component of what you're doing and how you're speaking. But I think it's even more important with these competitions over Zoom. What I was telling people, the teams last night, was that in real mock trial, you can use your movement in your open and close as another way to convey your message. You can use your body language. You can move around the courtroom to make points. You can't do that over Zoom. So literally the only thing you have is what Monica was saying. And so that's really, we really need to emphasize that when you're talking. I think Youssef, Monica gave examples for others, but your opening line of your opening statement, make sure that's separate somehow from the rest of what you're saying. Distinguish that line. That goes for everybody. In your closes, in your opens. When you're hitting a point, you have to make it sound different because we're writing notes. We're thinking about things, right? Pause, slow down, speed up, get louder, get softer, do something to distinguish your major points. So I really agree with what Monica was saying. For everybody, again, I'm gonna keep it general, like Christine said, do some more signposting, right? I think the opens, I really liked in the opens that you guys signposted, but also do it through your witness testimony. When you're moving through on a direct, when you're moving through on a cross, signpost, let us know what you're about to do. You always wanna tell the jury what you're going to do, then you do it, then you tell the jury what you just did. Make it easy on all the listeners. Technology, feel comfortable screen sharing, feel comfortable using Zoom. I agree with what Mark was saying about, looking into the camera. Make sure you're centered. Make sure, Mycal, I can't see you. Half your head's cut off. So make sure you're in the frame, right?
There's nothing there but forehead. I'm telling you.
Are you doing that on purpose? Is that why?
No. It's just,
yeah.
I have a big chair behind me. I'm trying to take it up because I haven't done my laundry.
When you are sitting there, when it's your witness and you're about to cross, but someone's on direct or vice versa, don't have your mic on mute, because you're not going to be able to object in time. That happened a couple of times in the tournament, where by the time you unpause your mic, make your objection, the witness has already answered the question, and then we don't even know what you're objecting to. I think if it's your witness, you gotta leave your mic on. Voir diring the expert witness. That I love doing that in mock trial. I think you should always do that. I was probably the extreme. I wanted to do it in every situation because I felt like regardless of whether the voir dire is successful, which it's usually never going to be in mock trial, it's a way to show your skill, your technical skill of doing a voir dire. So Youssef, I thought yours was excellent. Just know that in real life, when you're doing that, it's outside the presence of the jury, right? So when you are back in the presence of the jury on your cross-examination, those are killer questions. So you want to do those, again, in front of the jury. Now, we don't need to hear them twice in mock trial, but it's just something for you to know, or you can ask for it to be, constructively read into the record. But I think, if there's an expert witness, always do a voir dire on qualifications. I agree with one of the other judges who said, don't do thank yous, no pleasantries. Just get right in it. Just start off strong, especially on your cross. I think there was someone that started off their cross that way. You want to start off with a bang on your cross. So don't, kind of lead in with how are you doing today, that kind of thing. And I'll just, I don't want to be specific on the strategy of the problem, but generally in the opens, I really liked the road mapping. I think that's really important for you guys to do. Both of you did that very well. Again, just distinguish your speech a little bit. Billie, I thought your evidence was very good. I thought that your direct of the plaintiff was just very on point. From the flow to the organization, the structure, all of it. When you, and I think Mycal, you were crossing, this is kind of a trick that sometimes you see teams do in mock trial, so all of you should be aware of this. What teams do, and I know because I did this, was if there's something that's objectionable, sometimes teams, you ask the perfect question so that the question is not objectionable, but you tell the witness to bring whatever the stuff is that you want in their answer. And I feel like Billie and their witness did that often. All of Billie's questions were who, what, when, where, why, how. So you could not object to the form of the question, but the witness was just killing you guys on things, you know, Mycal, that's where you could object, you know, to non-responsive, or there's a number of different objections you can make there. I think the witness was like, my rights were violated and blah, 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 blah. There's like tons of stuff there. But otherwise, Bill, I thought your direct was very good. Your questions were very good. Mycal, I like that. And this went for everybody. This really went for everybody on your crosses. You guys, all of you did a great job of not letting the witness wiggle away. When they tried to wiggle around your questions, all of you locked them down before moving on to your next point. And that's exactly what you need to do. Youssef, you did that. That was awesome. You came out of nowhere, Youssef, with your cross. I thought it was great. It felt like in your open, you maybe read off the screen a little bit. And then in your cross, you seemed like you were a little bit like what Monica was saying, you were a little bit more you because you had to improvise. And when you had to improvise, you were better, right? So I thought, you know, I do that maybe in your open and in your direct. It gives it more of a natural flow. Don't just read off the page. But all of you on your crosses, I thought, did a really, really great job. Really strong crosses. Billie Billie on your cross, great objections. Your evidence I thought was really good. There was a lot of evidence issues I could talk about, but that's probably more relevant for another time. This is what I'm trying to read off, and I'm trying to be polite to Christine and not go into super details. Oh, impeachments. Make sure you guys know all just a little technical, what the difference is between refreshing recollection, what the difference is between an impeachment. Be strong on your responses to objections. The judge is always going to give you the opportunity to respond. You want to make sure. There's a lot of times where, and I was the presiding judge in another round where when there's an objection, I want to sustain it because I know what or I want to overrule it, but what the response comes in and it's not the correct response. It's not, the evidence is not there. So the judge is faced with this decision of allowing this thing in when they really shouldn't, but the objection wasn't appropriate. It wasn't there, it wasn't made correctly. This is one thing for the witnesses, and each of you guys had this. Witnesses cannot win you a mock trial round, but they can lose you a mock trial round. So what I always told my witnesses when I was, the plaintiff or I was the lawyer was, look, the way they design these problems, there's going to be good points and bad points for each side, for each witness, all throughout the case. That's just how these things are written. So if you're the witness and you are getting crossed on your bad points, just admit what's bad and let your lawyer deal with it either on redirect or in close or whatever. But what happens if you try to not answer the question or you try to get clever is you can really kind of lose the case can kind of get away from everybody. And the witness, you don't want to be the focus. So just let the lawyers deal with that. There are points that you're going to have to admit, but right, that's the whole point of the case. Oh, somebody else brought up the question where you said you want this court to believe that XYZ, and I wrote that down too. That is a super risky question to ask, okay? So for me, I would assess my witness that I was crossing. If they were a weak witness, I would ask it because I felt like I could make a point. If you have a strong witness, they could answer that question in a way that devastates your case. If you say, so you want this court to believe blah, 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 a savvy witness is going to say, no, what I want the court to believe is blah, 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 diarrhea of the mouth about why your case sucks. So I don't mind the question, but don't just automatically ask it because that could really be something dangerous for you guys. I've got a ton more, but I think that's fine for everything in general. You guys did a really good job, especially Christine told us it was on like 10 days notice. I told the other teams yesterday the same thing. It was really good. I would not have known that you guys just got the problem if the judges didn't tell us. So I just thought everybody was good. The Zoom, using Zoom in these mock trial competitions is, this is the first time. And so I think, we've got to be creative in how we utilize Zoom. So I'm going to be really interested to brainstorm with everybody on what we can do to kind of make this a little different. In real mock trial, you use demonstratives, you use, you write on the board, and it's kind of difficult here. It makes it kind of boring and mundane. So I'm interested to hear, how we can get creative, but otherwise I thought it was really super good round.
Yay. Okay. I have even less. So the message that I was sent from Brandon, who is a scoring judge who was not on the Zoom call, but was watching because we live streamed the whole thing, was good job incorporating comments we gave into the following rounds, a sign of really caring about getting better, which I love to see, which is true. I believe with all that. So y'all did a great job with that. The only other note that I have is, so the great thing about live streaming this on Zoom is as soon as I stop this live stream, with that same link, you can go back and look and watch it. I'm not saying you got to go watch the whole 3 hours of it, but take a moment and look at at how you look and how your presentation comes off. Because I don't think you realize when you're in the thick of things, how obvious it is that some of you are reading. And we think we're being real subtle and sly about it, but I will tell you this. I got a message from Jim Lawrence in the middle of opening saying, is so-and-so reading? And I'm like, that's not a good sign if he jumps on and the first thing he has to say is so-and-so reading. So I want you to really look at yourselves. So you don't have to watch the whole 3 hours or your whole 22-minute cross and voir dire, Youssef, but you should go back and look at yourself to see where your eye lines are, what it all looks like, and then be really mindful of that for the future. Because one of the things that we're going to be working on that we are still trying to figure out to teach you is how to be as natural as possible over Zoom and not look super duper scripted. That being said, this round ended up being exactly what we hoped. It was a super, super, super close round. And I say that because there were 5 voting judges. To be clear, I was not one of them, but there were 5 voting judges, and it was a 3-2 win for the plaintiff. So congratulations, Ridiculous Suit, on your win. You guys have a lovely certificate that will be framed, and I will somehow get to you to commemorate your win that you can hang on your wall or put nowhere because it's literally something I made on Photoshop, but it'll have your name on it and it'll still feel special even though it is not engraved. So I'm sure you all are exhausted. I'm sure you guys are all tired. It's your 3rd round today, but I just want you all to know how proud we are of all of you, and what you have done is really kind of cemented what we were hoping this tournament was going to do, which is give you guys a chance really early to show us what you can do so that we can decide where you guys can be the best asset to us in terms of competing. So I'm going to let you go because we're about to jump on another call to figure out who's going to go where while this is all still fresh in our mind. So thank y'all so much. We appreciate you. I'm going to finally stop this live stream. I'm serious.